I'm willing to have these people like physically attacked, but if you file it under seal, I won't do that? Like, what? Why am I Destiny in the court filings and not Steven or something?
I don't think they think you're going to attack someone. I think they think someone in your audience might be crazy enough to do it for you. And the more you keep saying to do it, the more they might take you seriously and actually do it. That's why. Because you have an audience. If you were a normal person, then this probably wouldn't be enough to get a gag order because you're just a guy talking shit. But you're a guy with millions of viewers on your YouTube channel. You've got, you know, tens of thousands of people watching you every night on stream. So there's a bigger chance that someone might not realize you're joking when you say it and may actually try to take action based on your words. You're held to a different standard than a normal person because you're a public figure. And I know he knows this because I've heard him say these exact same thing about other public figures in the past. Why he's suddenly now acting like he doesn't get it. Just like it's so transparent. Stop doing this, Destiny. Stop. You're like, there's too much content of you being smarter than this. You can't play the dumb guy. It's not going to work.
Purpose. Destiny addresses his lawsuit. This is February 20th. That text message was on January 22nd. Had I said anything publicly about this yet? How are my statements in the future scaring defendants in the past? Because that text message that they cited here, first of all, this is just...
I mean, it could still just be based on your reputation. They could be scared of you because of things you've said in the past about other creators. You can't tell them what they can't be scared of. Like, that's still a thing. Well, he has a history of threatening people in the past. He has a history of being scared. You know, like, I would believe any girl, even if they've had zero interaction with Andrew Tate, of saying they were scared of Andrew Tate, simply because of his reputation. Right. So we got here Destiny's lawsuit update, and the only place I seem to be able to find this is from Destiny himself. Can't find any other coverage of it. The other party involved in the lawsuit isn't talking, so the only place we have for updates is Destiny himself. So we're going to be taking this with a heaping helping of salt, because obviously he's going to be biased toward his side. So we're going to have to kind of read between the lines on this. So we're looking more at just what's in the document. And whether or not I agree with his interpretation of it, but the document will speak for itself. If he is actually showing the document, then I'll take that as a level of transparency I'm willing to accept, and to watch a Destiny video. So here we go. We're watching a Destiny video. I guess that's what's happening.
his reply in support of motion for protective order governing...
Let's see how fast he is if I put him on 1.5. Let's put him on 1.5. See if we can make it go a little bit faster.
Public commentary by trial participants. Oh, they want to do a gag order on me, so I'm not allowed to talk about it, which is
good enough.
Given, I will write it, man. This will be my final manifesto. I'll do a full write-up on this entire thing from start to finish, because nobody will cover this unless I write it all up clearly, just in terms of like all the unhinged, crazy, depraved behavior that the other side has done in the course of this whole case. But
yeah, so they're behaving in the way I think people should behave during a lawsuit that I can't believe Denham's and Frogan and them aren't, which is the side that's suing him has been fucking radio silent. And not only do they want to remain quiet as possible, because these are public figures involved, they also want the other public figure, in this case Destiny, to shut the fuck up as well, which he's not doing. So they're trying to get a gag order on him in order to force him to shut up until the case, because that's the difference between like normal people, because normal people are like, well, you can talk about your case, it's fine, you can talk about your case. Yeah, you can, but you're a normal person. For a public figure, when they're talking about their case, they're doing it in front of thousands, if not hundreds of thousands of people publicly, and it could change the public opinion of the people involved in the case if all that information is out there, and anyone that's on the jury or anyone involved in the court case could go look at this information. It could influence them. These people are influencers. So you want your jury, you want your people involved in the ruling on a case to be non-biased third parties, which is hard to do with public figures because they won't shut the fuck up. It's the same thing with like a celebrity trial. Like, it's so hard to find jurors for a celebrity trial who haven't heard of Johnny Depp or Amber Heard, and how do you get them to be non-partial? Like, it's a lot harder than when it's just two random people that the jury's definitely never heard of.
Comes now plaintiff Jane Doe by and through undersigned counsel, and hereby submits her reply in support of her motion for protective order governing public commentary by trial participants, and respectfully states as follows. Defendant's opposition to plaintiff's motion grossly mischaracterizes the nature of the relief sought, the applicable legal standards, and the relevant facts. Plaintiff does not seek to muzzle the defendant, nor does she seek to prevent him from defending himself in court. Yeah, no Sherlock Holmes. Rather, plaintiff seeks a narrowly tailored protective order that applies equally to all trial participants. Well, because she's already gotten her bullshit out there, but okay. And is only intended to curb the ongoing harassment.
Oh, wait, what bullshit did she get out there? Because I didn't see any posts from Pxie. Like, I haven't heard any updates from her. Are you going to show that? Show what she got out there. Show what the bullshit is. Because I haven't seen any posts from Pxie, so I have no idea what the update's supposed to be for her. It's like when Alex Jones wouldn't shut the fuck up about his trial. Yeah, like everybody knows who the fuck Alex Jones is. And when he won't shut up about it, and no one knows who these families are, so even if they do speak out on the trial, like that's another thing. When one person in the trial is a famous person or is a content creator, if it's between two content creators and one person in it is, like Destiny is just so much bigger than the other ones, it's hard to get a jury that won't be influenced by it, because when they speak, their voice is going to dominate YouTube, it's going to dominate social media. Just like when Alex Jones spoke, his voice dominated news cycles. And when the victims' parents spoke out, not nearly as many people saw that. So that could have influenced the jury. So typically you want like a judge, a legal professional to rule on those cases, because they aren't going to be influenced by that stuff. They're going to do their job. They're going to stick to the letter of the law, which is what I think will happen in the Ethan case, because you can make those same arguments for the Ethan case. Oh, he's such a bigger creator, more people are going to listen to him. And I'm like, well, the internet actually seems pretty split between those two. It's always like you can find people on both sides pretty easily. But I don't think that they'll make it to trial because it's so cut and dry that I think the judge will just rule on it. So I don't think influence is going to matter nearly as much there. For this one, there's a lot of ins and outs to this one that I don't think a judge can just rule on in the same way they can with the Ethan case. So I think Destiny's is a pretty good shot of actually making it to trial compared to, the Ethan Denham's, Ethan Hassan influencer, Hassan Orbiter case. So a little bit different there. Destiny is definitely way bigger. I don't know many people who've even heard of Pxie. They just know that she's some chick that he banged, and she was an orbiter of his, or saw as an orbiter of his, because she came on his streams. And this is a little bit different. This isn't two separate communities going at it. It's a large content creator going against one of his own like orbiters, basically, or her going after him. To be clear, he has admitted to the thing that she's saying he did. It's the why he did it and whether or not it's illegal that's being argued. So if you're going with a moral stance on Destiny, he definitely did wrong. There's no arguing that. And he definitely shouldn't be trusted with nudes or anything like that ever. I don't know how he gets women to begin with, other than the fact that he's rich. He's not a looker. But, hey, different strokes for different folks. He has, however, violated their trust in a way that is absolutely morally wrong. God damn it, he's running away.
Intimidation and misrepresentation that threatens the integrity of these proceedings and deter witness participation. See proposed protective order, blah, blah, blah. Okay. The record is clear. Multiple potential witnesses have withdrawn their willingness to testify due to fear of retaliation and doxing by defendant and his followers. There's never been any evidence of this submitted, ever, but okay. Defendant has made explicit threats of violence against plaintiff's witnesses. Again, Queeman and Dristigal are not witnesses in this case, so it has nothing to do with that at all, but I guess you could just lie over and over and over and over and over and over and over again in every single motion, I guess, you file, but okay. Disparage plaintiff, true. Her witnesses, kind of true. But I mean,
you can't lie over and over again in every motion. I mean, you can, but they're going to check the facts of the things that you lied about in court. So when this makes it to court, like harping on whether or not Dristigal lied and all that stuff, like it really doesn't matter, because it'll come out in court. Like, that's what discovery's for. They'll find out that he lied, and those will just get stricken from the record and thrown out. And if he did it under perjure, if he did it under oath, then he's perjured the court as well. So it's a little bit different. Let's grab this. Use that to get the fuck up out of here.
I mean, like, all of them are actively and continually chatting in Dristigal's Discord server. Like, these are the least secretive people ever. Her witnesses and her attorneys, in repugnant terms, get over yourself, who cares, disclosed the sealed identity of plaintiff. Her name was literally posted on her GiveSendGo when she initially published it. But also her name was used.
Yeah, and the argument that it's doxing because legal names are used in legal stuff, it's just, I hate hearing that so much. That's just people telling you they don't know how court works. I do think it is kind of funny that she did it herself first, that she put her own legal name on the GoFundMe for her own thing, and then later like updated it to change it. So whoops, she kind of doxed herself at first. But it's still not doxing because your name's going to come out. Once you're in a court case, your name's just going to come out. Like, what the fuck? Oh, I didn't even see that guy over there. Like, your name's just going to come out. Like, that's how court shit works. Same fucking guy from earlier, too. No. I don't want to go change skins. Is the girl whose nudes this is the girl whose nudes he leaked? He didn't leak her nudes. In fact, I don't even think she's nude in it, to be honest with you. I haven't seen it, but from what I understand, she's not even nude in it. It is a video of her sucking his cock. I think she's still wearing clothing while she's doing it. So the only ones nudes who are technically nude in it is him, because you're seeing his penis. I haven't watched the video for that reason, but I have no interest in seeing Destiny's penis. But from what I understand, it's just like him holding the camera and her just bobbing up and down, and then she looks at the camera and people are easily able to identify it's her because you can see her face in it. So that's the thing. It is her sex tape. It is her performing a sex act, but she's not nude, I don't think. I could be wrong on that, but I haven't seen it. I don't want to watch it, but I've seen people describing it, and it's basically, oh yeah, she's just either fully clothed or in her underwear, like she's not nude, and sucking his dick, which she thinks is going to ruin her life. I'd argue, I don't think it's going to ruin your life, but he did violate your trust, and he should have got your consent before sharing that. Like, he made a lot of mistakes. There's no denying that. He is in the wrong. I don't think it legally constitutes revenge porn because they're going after him in a lawsuit instead of in criminal court, because revenge porn would be a criminal crime. So I don't think it's legal revenge porn, but it's still wrong.
It's the same day she filed for a protective order. After that, I haven't done it at all. I've removed it when they've asked, but I like how she keeps saying this over and over again. And published private communications on platforms with hundreds of thousands of viewers. Yeah, this isn't illegal. There's no law against this. But defendant claims that plaintiff continues to attack and malign Buy Now online, but provides no evidentiary support, nor can he, for this false contention. Defendant opposition further asserts that plaintiff's public statements include vitriolic attacks on Buy Now and his attorneys, but again provides no evidentiary support, nor can he, for this false statement. I mean, she tweeted about the denims. No? Do they just say that doesn't count here? Plaintiff requests that these unsupported and false statements by defendant be...
Wait, but what does the denim shit have to do with your case? Like, wait, what was the claim being made there? Let's back this up.
Public statements include vitriolic attacks on Buy Now and his attorneys, but again provides no evidentiary support, nor can he, for this false statement. I mean, she tweeted about the denims. No? Do they just...
Yeah, but they're talking about, like, stuff against you and your employees. If she's tweeting about the denim stuff, that's not related to you. I'm not sure why you're bringing that up.
Say that doesn't count here? Plaintiff requests that these unsupported and false statements by defendant be stricken from the record pursuant to Rule 12F of the Federal Rules of Civil Procedure. Plaintiff also requests that the court admonish defendant...
Yeah, they're saying that you won't shut up about it, and you're saying things that aren't true and that you can't prove are true, and you need to stop. And your response to them is, well, she tweeted about the denims thing. Okay, so she tweeted about a different case, though. What's that got to do with yours? I don't understand.
Defendant's counsel for litigating in bad faith and or impose sanctions pursuant to Rule 11. I see that it looks like they have somebody...
What's up, Brand? Welcome back, my friend. Oh, I don't know if you heard me last night, 'cause I think you dipped out of the stream too early, but thank you for the donut last night, man. Appreciate it. Very generous.
else writing these now, because this one is formatted quite a bit differently than the other ones. I wonder if they hired somebody else or if one of the other lawyers are writing these now. Are you not allowed to say her username? Pxie? I can say Pxie. I'm just not supposed to use her real name. This is though, like, when people do these cases with protective orders because they don't want to be known or they don't want to be associated publicly with the case. Pxie loves the public association. She wants to be publicly associated. She just doesn't want to be quote unquote doxxed, which is like a child's term that you use online for not wanting people to know your name, but it shouldn't really apply here in a court term. Retroact.
He's right. It doesn't apply in court. You can't want to talk about the case and want your side out there and have all this legal documentation that's publicly available, it's public record, it's open to the public, and then also not want people to know your real name. Either you don't care if they know your real name and you want them, because if they look at the legal documents, they're going to see your real name. It's just going to happen. Your legal name is on the legal documents. That's how that works. If you want people to go look at it, then you have to be okay with them knowing your real name. If you want to protect your real name, then you got to shut up about the case and hope they don't see the legal documents. Hope people don't look at it and not bring attention to it. It's already out there. It's too late. You can't take it back now. That this illegal case, they're going to use your legal name. That's just how it's going to work. How much just installing DC Universe Online? I don't know if I'm going to do the new season of Diablo 4 or not. I haven't played DC Universe Online in years. I don't know if I'm going to do the new season of Diablo 4 or not. I wasn't real impressed with the last season, and it seems like with every new season and every new update, they make it more and more like Diablo 3. And I was excited for it and bought Diablo 4 when it first launched because they promised it would be more like Diablo 2, which is my favorite Diablo game. I wanted a return to form, more to that, where you're not this godlike character who's just massacring demons by the thousands, and it's just this high-speed slaughter fest. I wanted the more slower paced. It's an actual struggle, and you have to actually put some thought into your gameplay. You can't just keep holding down your ability buttons and watch everything die, but you have to actually put some thought into the gameplay. And that's what Diablo 2 was. Like, those fights were a struggle. You actually felt like you were fighting the hordes of hell. Now they just all feel like cannon fodder, and it's bad, and I don't like it. That's what Diablo 3 was, and I didn't like it, and they're making this more like Diablo 3. And with every new update they make more like Diablo 3, that's less. I wanna, oh, fuck you! Oh, good, no fall damage, weird.
Actively looking back, I wish you would have fought the initial protective order. I don't know if there's a likelihood of success on winning there, but maybe it would just a waste of money. If I was representing myself, I would have fought the protective order. How you can ask for a protective order when you've already publicized all of this online and wrote a Substack and everything else about it? It's an exceptional use of a protective.
That's going to be his biggest argument right there, that I think it'll probably keep them from putting the gag order. I think she had a good chance of getting a gag order before she posted the Substack, but all he has to do, all his lawyers have to do with this like gag order in order to shoot it down is say, she talked about it first and she gave all the information in a Substack, and then they can just show the Substack. She just made this long post outlining the court case, like she gave all the details first. So you're basically saying it was okay for you to talk about it then, but it's not okay for him to talk about it now. Either you don't want it talked about and you want everybody to shut up until the court case, or you're going to post about it and then he's going to get to post about it too. So, like, we have to be fair here. I don't think, for the record, I don't think either one of them should be talking about it. I don't think anybody should be talking about a court case they're in when they're in a court case. This is the absolute dumbest thing you can possibly do. You shouldn't do it. They definitely shouldn't do it as public figures. But she did start talking about it first. So he's just, okay, well, if we're going to talk about it, we're going to talk about it. Now, he's talking about it a lot more than she did. She made that one post, but it doesn't matter. Like, it doesn't matter if he talks about it more or less than she does. Once she talked about it, she basically made it fair game.
Protective order. And if you look at any of the other cases around this, like, nothing is ever done like this. Like, this is just being wild. Instead, even the evidence submitted by defendant shows that plaintiffs' limited public updates, in contrast, have been respectful and have not disclosed confidential information, threatened any party.
Why is the SMG more accurate at range than the AR? Sorry. Just Fortnite's fucking wild, man.
Or deterred any participant. Rather, they seek to encourage participants. How do I even get participants on my side of this? I mean, I don't know what. Why would the person not being protected help you, Destiny?
What do you mean, how do you get participants on your side? You're a bigger creator with a bigger audience. It's pretty easy to, like, get participants on your side. I mean, she's got JStalk, but I'm sure you can find other people to join you in the lawsuit as witnesses or whatever if you really wanted to. I don't know why you're acting like you can't.
There's a public interest to court proceedings being public. There's a public interest to people's names and reputation. Like, if you're filing stuff in public court, you're making a claim. You're basically saying that I think that I've been injured in such a way that I think the state needs to intervene and grant me relief for this particular thing. And all of us have a public interest in having access to the records on that. That's why all the court filings are public. Protective orders and things protecting names should be exceptional, and they are exceptional rather than the rule for these types of things. But
the only time, like, your legal name is protected in legal documents, like a court case like this, is when revealing your identity would put you in physical danger. So, like, if they have a witness for a case, for instance, and that witness is in witness protection because you know you're going up against the mafia or some shit, and they might try to kill this witness, we need this witness's identity protected even when they go to court until the court date when they show up. So that's, like, the only time.
defendant opposition ignores the governing standard, the substantial likelihood of material prejudice test set forth in Gentile v. State Bar of Nevada, which courts in this district routinely apply. The proposed protective order meets the standard and is the least restrictive means of protecting the judicial process. I'm not going to bother reading all the underlying cases.
Casey is incriminating herself more and more every day. Post shit in the Discord. We may look at it later. I don't know how long this is. We're gonna keep up with this. I'm just trying to get the gist of it. I'm not trying to watch the full 2-hour VOD here he's got, but I'm just trying to get the updates. It looks like they're trying to file a gag. So far, what I've gotten is, and we may skip around on this in a minute after this match because it sounds like this legal documentation is going to drone on for a while. Sounds like they're trying to be as thorough as possible. I want to hear what the arguments are, but it's definitely not going to be as entertaining of a read as like Ethan's was. It's not going to be Mimi. This is going to be very much legalese, lawyer speak type stuff. So, what are you doing? Why are you just standing there? Okay, well, just stand there then. But I may skip around. Like, I'll get the gist of it, and the gist of this part right now that we're watching right now is she wants a gag order for him. I'm trying to see if there's anything else that she wants or any other updates or claims being made. But so far, we're still in the gag order.
This is every time I do, they're horrendously miscited, but I don't know if it is or isn't here. Wait, if they're saying you provide no proof for speaking online, why not just submit the tweet to the court as evidence or whatever? We probably did in the last motion. But these guys just say whatever. They just lie over and over and over again. And until the judge starts ruling.
We mean probably did. Do you not remember the things you submitted to court? Or your lawyer's just handling stuff and you're not checking in on them? I mean, if you're going to be talking about this and you're going to be giving people the facts, then you need to know, like, people can't ask you what you've done on your side and you'd be like, I don't know.
On things. I mean, I think we're supposed to get some rulings on these motions, hopefully within a week, but the big one will be what the magistrate judge recommends in regards to the preliminary injunction. And then hopefully I get approval to go over that transcript publicly. Contrary to defendant's framing, the proposed protective order is not an asymmetric gag order. It explicitly applies to all trial participants, including plaintiff. Didn't she imply that your lawyer was a defender on Twitter? Wouldn't that be an example of her attacking lawyers? Yeah, I don't remember if Andrew included that in a briefing or not, but yeah, I think she did tweet that initially, that Destiny got the lawyer who defended, these guys or whatever. Are your counsel or you planning to respond to these motions? No, there's a name for it when you have a right of reply. Where are my lawyer people at? What's it called? Like
the right to reply. It is a thing, but it doesn't. Yeah, it's not called right to reply. But he's right. You do have the right to respond, which is his argument here, is that you shouldn't put a gag order out against me because she spoke first, and I have the right to respond. It's not right to reply. I think it's right to respond. Like, you don't have to reply directly to them. You can respond publicly if you want. So, small distinction there. But he is right. There is a such thing as the right to the right to reply, but I forget what it's legally called.
A right to reply. Like, we've already given our response, or we've already given our response to their motion, and I think this is their response to our response to the motion or something. Let me check. Hold on. We're not entitled to file a SUR reply. SUR-reply. I'm guessing it's like a required response to a thing, so we don't have a right to respond to the response, basically. You can explain why they sealed it. For layman's, it looks like...
Yeah, so you can't just respond endlessly back and forth. Somebody makes a statement, you have a right to reply to that statement or respond to that statement, and if they want to make a rebuttal, then it has to, like, stop there. You don't have a right to respond to the response. You can't just respond endlessly and the two of you go back and forth in responses before the court case. Like, the arguments are supposed to be had in court. That's what court's for. You argue there. I started playing Stellar Blade today. I've never seen that much cheek in a game in my life. Oh, you've never played Dead or Alive, brother? It's one of my favorite series. Not just because of the cheek. It is also a shockingly good fighting game. That also happens to have a lot of cheek. And stellar jiggle physics. Oh my god.
It's the court siding with them because they have reasonable arguments to seal it rather than being standard operating procedure. Well, they haven't sealed it yet. It's just sealed until the judge makes a ruling on it. I think generally when you request things to be sealed, they'll be sealed until the judge makes a ruling on it, because if it's open and then they make a ruling to seal it, it kind of defeats the purpose, right? But I'm pretty sure that I think it would be exceptional if they agreed to seal that after it was already an open court and they really didn't have any good legal arguments for it. So it explicitly applies to
you'd have to have a real good argument to seal public documents once they've been made public. Like, typically this, like, motion they're doing now where they want the court documents sealed and not made public, which that's not uncommon. Like, these things are public record, but when they become public record depends on whether or not they're sealed. So if you don't want a court case, especially if it's a court case involving public figures, because you don't want public opinion to influence the case, then they'll seal the court documents until the case is finished, meaning it's public record, but it's not available to the public until the court case is over. Sounds like that's what they're trying to do now. They're trying to get this sealed because they don't want people talking about it. But I think it's too late. The court, like, the proceedings have already started. Like, they've already started going through this stuff. It's already been filed, and it was public already. So now you're trying to take things that are already available to the public and take them away from the public and seal them. And I don't think that's how that works. Like, I don't know if you can seal them after the fact.
All trial participants, including plaintiff, and prohibits only that public commentary which disparages, threatens, or intimidates parties, counsel, or witnesses. Disparages? Like, what? I can't say Like, it's so crazy. Discloses sealed identities or confidential attorney communications. You don't need an order for this. It's already not okay to disclose sealed identities or confidential communications. That's why the identities are sealed, and that's why these communications are, if they're confidential. So I don't know why, you would ask for an order about that. Misrepresents legal filings or court orders. How, like, are you allowed to be recorded? If you think I'm incorrect about how I'm representing something, then fine. But I mean, like, I want to protect order against misrepresenting. Like, what does that even mean? Okay, but
It means that they want you to not be able to say things that they think misrepresent them. They want a court order to shut you the fuck up. Same thing you already said. It's still part of the gag order. Like, they don't want you talking about things, even if you're giving the factual truth of the matter when you talk about things and you're just reading the court documents. Your tone of voice or the way you're presenting it could imply things. They just don't want you to talk about it at all. That's basically what this is boiling down to, is they don't want him talking about it at all anymore.
discloses sensitive personal allegations or private details of the parties or witnesses.
Which they'd have a good argument for that. Because his argument is going to be, well, I'm not saying anything that's wrong. I'm just reading the facts. I'm just putting my side of the story out there. And then their argument could be they could show, stuff from his fan base where they've gone around parroting things he said or adding their own stuff to it. And then they can say, see, he's clearly influencing people in a way that it's, even if he's not meaning to, he's leaving them. What the fucking? Why are you shooting at me? You're an NPC. Okay. He's influencing them in a way where they believe this to be true, even if it's not. And then they can show that, see, he has changed people's public perception. And that's all they would need to show there.
Like, all of these people are constantly talking about me in Jessica's server. Like, I can't say anything about any of these people ever now. And also applies to every single person, like potential witness. I don't even know what a potential witness is in this case. Apparently anybody can be a witness ever. Trump could jump onto this case, I guess. Such restrictions are...
Yeah, that's what that means. Potential witness is anybody. When you're a public figure, yeah, it could be anybody. In other words, shut the fuck up. They don't want you to talk about it. I don't know why you're acting like you don't understand this stuff, because I've seen him go over court cases for famous people and other YouTubers in the past, and he seems to have a full knowledge of how this all works. And now that he's the one in the hot seat, he suddenly doesn't know how this works, or what does this mean, or what is this? Yeah, I don't believe you don't know what these things mean. I've seen you properly interpret this stuff in the past. I think you know full well what all of this means.
well within constitutional bounds. Defendant's reliance on this case and this case for his contention that the proposed order violates his First Amendment rights is misplaced. Both cases are inappropriate or inopposite since they involve broad restraints on the press, not on trial participants. The Supreme Court and other courts of appeals have recognized a distinction between participants in the litigation and strangers to it, pursuant to which gag orders on trial participants are evaluated under a less stringent standard than gag orders on the press. Oh, cute. Are they actually trying to read through the cases now and cite them in their motions? Am I inspiring them on stream to do their job? Good job. I'm too lazy to dig through these cases, though, so.
Yeah, you're kind of shooting yourself in the foot with these streams because you keep telling them what they're doing wrong so they can correct it in the next filing. I still think it's in your best interest to shut up. I know it's good content for you, but I don't know why you're not shutting up about this, especially since you're the defendant. There's a pretty good chance you're going to get in a lot of trouble if this goes south. So shut the fuck up.
Nebraska press is further distinguishable because the prior restraint was struck down due to the lower court's failure to consider less restrictive means or measures. CB's is also distinguishable because 1, there was no evidence of actual or potential prejudice to the proceedings, and 2, it was a white-collar crime case where the courts have found a less significant danger of prejudice compared to cases involving lurid subject matter, which carry a more significant danger of prejudice. In contrast here, 1, less restrictive measures would not suffice or suffice. And 2, plaintiff has presented evidence of actual and potential prejudice. And 3, the lurid subject matter of this case carries a high risk of prejudice. 3, plaintiff has demonstrated substantial likelihood of material prejudice. Defendant contends that plaintiff has not demonstrated a substantial likelihood of prejudice to the proceedings because 1, this case is an early pre-discovery posture, and 2, plaintiff has only demonstrated speculative harm or generalized discomfort. Both of these arguments fail. First, this case is not in early pre-discovery posture. Discovery has already commenced. Written discovery requests have already been exchanged by the parties, and responses are due. However, the parties agreed to wait or await the court's ruling on plaintiff's motion for a protective order governing discovery before exchanging responses and documents. I don't know if there's like a formal distinguishing thing between pre-discovery and discovery.
Hello, hello. What's up?
Not much. Just got home from work not about 10 minutes ago.
Well, welcome aboard. I'm just going over court stuff.
Oh, fun.
Yeah, it is fun. Although this is the boring kind of fun court stuff, not the fun kind of court stuff like the H3 lawsuits were. They were a fun read. I did read those on my channel if you want to see what court documents look like and see how they can be funny. If you want to see like the most damning example of court cases ever, check that out. It's a pretty fun read.
I've seen my fair share of court documents this past year, so I'm
Oh,
good.
these are unlike any you've probably ever seen or read. Holy shit, dude. These were hilarious. Like
Really?
some of the shit in them, I was like, wow, they actually put that in the legal document. Holy fuck. It's
It's
it's pretty wild.
like,
The Casey Tron one is
it's like,
particularly funny.
okay, then. I'm guessing it's like, why would they even have to add that? Oh, wait, no, that's why.
No, it's just the verbiage used and the way that they just absolutely pulled no punches.
Ah.
Oh
Because the
my
way you're
god, it's
describing it, it
hilarious.
reminds me of like the Sheldon meme of like, why? Why? Flips page. Oh, that's why.
No, it's just the way that they describe things, the verbiage that they use. Like it's pretty obvious why they're saying the stuff they're saying. It's all evidence against her in court. Like, for instance, in the Casey Tron one, the lawyers counted not only the number of times she took bong hits during her reaction to Ethan's video, but they also calculated the amount of time she spent smoking pot versus the amount of time she spent actually commenting and reacting to the video to prove that she spent more time smoking pot than she spent actually reacting to the video.
Ah.
It's just like, and then they use words like she was so obliterated. She was so like, yeah, like they pulled no punches. And she is so fucking high. Yeah, like they just made her, no punches pulled. They tried to make her look like the biggest fucking pothead burnout piece of shit on the planet. And they pulled no punches on it. I mean, they're not wrong.
How about they? I mean, were they wrong?
And they included screenshots. So it's not just her taking 42 bong hits during her reaction. It's also the fact that she used several different devices for smoking, some of which I'm like the judge is going to look at and be like, I don't know how you're not an addict if this is how you're smoking. Like she pulls out this like 3-foot tall bag at one point. It's apparently it's called a volcano bag. It's used for smoking, but this thing is huge. And she's just like sucking from this bag. Yeah, it's just, oh my God. Yeah, like she looks like an absolute addict in these pictures.
I mean, I've heard of one since my cousin has shown me one, but it's like I have no idea how the fuck it's being used.
I had never even heard of this thing. And then I saw that and I was like, oh my God. And then you put that in front of an old judge who's probably had to rule on, people committing, drug crimes in the past and, smoking pot and whatnot. And then seeing these insane things she's using to smoke pot from. Because she pulls out a bong, she pulls out a pipe, she pulls out this giant bag. It's like, wow, she is just going above and beyond to get as high as possible. Like there's like arguing that she's an addict when he's got pictures like that and he's got all that stuff is gonna be really hard. It's like really hard to do. She looks really bad in this. Holy shit.
She looks out off her rocker.
She looks like stoner movie, like comically bad. It's insane. Yeah, so that one's worth reading. I mean, you can watch me read it if you don't want to read it. You can listen to it like an audiobook. It took me a few hours though, but the whole thing is great. What's that?
Almost as high as Shaggy, where Scooby starts talking to her.
Dude, yeah, she looks bad. He makes all of them look really bad. Hers is particularly funny just because she has made it so easy for him to make her look bad. Like she has shot herself in the foot so many times that I don't see how she has a defense at all. It's really bad for her. It looks really bad for her. The other ones also Denham's also looks really bad. Frogan, I think, is the only one who has kind of a fighting chance, and even she looks pretty guilty. They all look really guilty. Like, each one of them basically admits to their crimes on stream. And he quotes them in the filing. Like, it's going to be real hard for them to get out of it. So if you want to see, like, what a court case looks like when you're just beyond fucked read theirs or watch me read them. They're great. Plus, you can also like the videos and help me boost my engagement while you're there.
Yeah.
The Destiny one we're looking at right now. This one looks way more up in the air, like it could go either way. I know, morally speaking, Destiny's in the wrong and everybody wants to see him lose. Myself included. He does need to be punished. But the question isn't whether or not what he did was morally wrong. The question then becomes, is what he did illegal? And it wasn't criminally against the law. It is now. The law has changed.
Initially, it was morally.
Well, the law has changed since then. So initially, when he did it, it wasn't a crime.
I was about to say, could they go back and...
No. Crime laws can't be applied retroactively. So they're gonna, what he did is against the law now. But they can't go back and say, well, damn it, why didn't she get up and run? I clicked the button like 3 times. Oh, God damn it. I fucking hate the controls in Fortnite. Of course he had an NPC with him, so I shot the wrong one. But anyway, so what he did was against the law now, but it wasn't against the law at the time. So that's why they can't take him to criminal court. They're suing him. So basically he shared, and it's, and there's levels to it. So he shared a sex tape of this girl. It's him and this girl. And he shared their sex tape with another girl.
That revenge porn shit?
Well, no, it's not. Well, I mean, now it would be legally revenge porn, but the way he shared it back then, it wouldn't have been.
Okay.
So he shared it with another girl in DMs that he was trying to get in her pants. So the way the law was written back at the time, in order for it to be revenge porn, it would have to be published. You would have to publish the porn. Sharing it privately in a DM isn't publishing it. So that's why what he did wasn't against the law at the time. Now it is. Now you can't share it at all without consent. They changed that law last year or the year before that. But this happened a few years ago. So he was not breaking the law at the time because he shared it privately. Because he shared it privately in a Discord. However, the problem arose when the girl he shared the girl he shared the sex tape with, the girl he was showing it to, because he was trying to show off his skills, I guess, to get in this chick's pants. Because his argument is, I didn't share her sex tape. I shared my sex tape. She just happened to be in it. And 2, I didn't share it publicly, so it's not revenge porn, which people go, oh, that's bullshit. But I'm like, well, legally speaking, he's not technically wrong. It is.
At the time, it wasn't classified as revenge porn.
Yeah, he was in the sex tape. So it is also his sex tape. It's both their sex tape. And the argument does, do you need consent from both parties to share it? Each party is entitled to a copy of it, but do they need permission to share their copy? And at the time, no, you didn't. You do now. But anyway, the problem arose because it went public. And the reason that the sex tape went public was because the girl he shared it with, her Discord got hacked. And people went through her DMs and found his message to her with the video and downloaded it and shared it. So, like, the question then becomes, well, how accountable do you hold Destiny for this going public? Because he couldn't know this girl was going to get hacked. But he also shouldn't have shared it in the first place. But sharing it in the first place wasn't illegal. So can you really hold that against him? Yeah, and that's kind of where we're up in the air at it. Is
the rabbit hole of that one.
It's a little more complicated. It's like, well, he shouldn't have shared it. But then his side's going to go, well, it wasn't illegal to share it at the time, so how did he know he shouldn't have shared it? And the judge has to decide whether or not it was okay for him to share that. You can't really hold her getting hacked against him. There's no way he possibly could have known that this girl was going to get hacked and that it would go public. And then it's like, well, how much do you put on the girl? Because it's like, well, why would you make the sex tape if you never wanted it to be seen by anyone ever? You know, you're trusting it to him, to one guy. Why even make the tape at all? Like, the purpose in making stuff like this is to show it to people. Arguably, the purpose is to show it to people. And then her argument's probably going to be, well, I meant for his own private use because he wanted it to, watch later for his own pleasure. I didn't mean for him to share it with anybody. So this is one of those things where I mean,
It's a rabbit hole.
morally, it's clear that Destiny's in the wrong. I don't think anybody agrees with what he did. But legally, this is really one of those things I could see going either way. So we're looking at the update now because her side, she released a Substack explaining she was suing him and like giving all this information. And now he's responded to that by showing the court documents and showing that, yeah, she's really suing me and he's going over that. And now they're sending him, they filed a motion for a gag order. They want him to shut up about it. And he's reading that on stream, so I'm watching to see their reasoning for wanting him to shut up. And I don't know if they're going to get the gag order or not, because you're right, the more attention he brings on it, the more it could sway the public opinion, because he is a big influencer, he has a lot of influence, you know, he could sway public opinion, it could affect her. But also, you can't really file a gag order on somebody to shut up about a case if you talked about the case publicly first, and she did, because she announced the case and gave all the details first. So he was responding to that, which you have a right to respond. So I'm not sure that they'll get this gag order.
Or at the very.
It's also my understanding that she's been pretty silent on it since then. If she has said stuff about it, I hadn't seen it, so it's definitely not as public as his.
I could also see the judge doing a modified gag order where you can't cover it anymore, but what's out there is what's out there. You can't talk on it any further.
Well, I would need to see, and that's what I'm hoping he'll show in this video, is her talking about it more than just that one Substack she posted. Because you do have a right to reply. So she posted the Substack. Yeah. He talked about it to reply about it, and which he had the right to do, and it should have ended there. If they filed the gag order there, and he's still talking about it, you can go, well, he already responded. Yes, he had the right to respond. He gave his response. Now we need him to be quiet. But if she then responded again and talked about it again, okay, well, now he's got a right to respond to that too. Yeah, like the more she talks, the more he has the right to respond to that. Yeah, like the back and forth has to end somewhere. And if you keep talking about it, he's going to keep talking about it. And then, yeah, the judge isn't going to grant the gag order. However, if she only talked about it once, and here we are 3 months later, he's still talking about it, you can go, okay, he's being excessive. And the judge might give it to him. So it really depends. I'm kind of going over it to see what other stuff he covers here.
Okay.
And whatever. We haven't turned over any discovery.
Sorry, I wasn't around all weekend.
Ah, it's all right. It's all right. What is happening? Where is... I do not understand the Instagram app. How do I get to my friends list? How do I just see the people I'm friends with? How do I just see my followers list? Have somebody... fine.
Not sure. I don't use Instagram.
Yeah, I follow a bunch of people, but I don't know how to even access that list. There's no button on this app. Where are you? Okay.
But I will say, yes, the weekend was hectic and stressful and as fuck. It was fun. Granted, I drank a lot.
Well, what happened on your weekend? Because mine was pretty stressful too, and I am, going to remind chat now if you guys want to super chat or donate or become a channel member. I have to buy a new car, so that would be very helpful. Click on your picture on the bottom right. Then click on your following. Hold on. Okay. Well, this brings me to my profile, but how do I click? Where's my following? All I see is my post. You mean where it says 817 following? Oh, I thought that was just text. Okay, so I can't click on that. Wow, that's not a button. That's not very clear. Okay, thank you. Now I can find the people I'm looking for. Damn, Jesus Christ, Instagram. Your UI is fucking terrible. I didn't even realize that was a button. I thought it was just like a piece of text giving my stats. Like if you go to my Twitch page or my Twitter page where it shows how many people I'm following, like you can't click on that number. You have to like it just tells you how many people I'm following. It's just stats. Okay. Instagram's weird. Anyway, what happened to you over the weekend?
This weekend was my wedding.
No, I thought that went until the 10th.
No, that was this Saturday.
Oh.
Well, this past Saturday, the 28th.
Well, congratulations. How'd that go?
Really good, actually. After everything was done, I had maybe an hour to actually...
Okay, so you got married So you got married over the weekend. It's now it is now Wednesday, and you're in my stream talking to me. So I gotta ask.
Yeah.
Well, when's the honeymoon? Did you not immediately go on a honeymoon? That was a short honeymoon.
No, that's the 13th to 27th.
Ah, okay. So you planned it out. Yeah, Instagram
Yeah,
used
no,
to make it look like a button, but now it's just text. That's weird. Like, I genuinely didn't even know I could click on that. Cool.
The 13th to the 27th in Hawaii.
Well, your weekend sounded like the fun kind of eventful. I'm mad you didn't call me and try to FaceTime me so I could be there virtually. Shame on you.
I didn't have my phone with me all Saturday.
You mean to tell me that not a single person at that entire wedding had a phone or a tablet you could borrow?
No, at Discord.
You can download Discord. Also, I have things other than Discord. This is unacceptable, sir. Unacceptable. Your weekend sounded a lot more eventful, a lot better than
I
mine.
admit, I left my phone in the freaking hotel room.
Well, over the weekend, was outdoor dashing, and I got hit by an Amazon truck. It was totaled my new car I've only had for like 3 months anyway. So this is already a new car. First new car I've had in years. I've made like 2 payments on it, and now it's been totaled by an Amazon truck. Which I've been back and forth with insurance trying to get that taken care of. I'm hoping that Amazon will just, like, they won't put up much of a fight about it. I'm assuming they have some kind of system in place for their trucks getting into accidents, because given how many trucks they have on the road and how many deliveries they do every day, I'm sure that they probably get accidents for their trucks all the time. They should. I've got my insurance, talking to them and trying to handle this. They should have a entire department to handle this, though, I would imagine. It just sucks because right now I'm out of a car until insurance says they'll pay off the old car, or the one that got totaled, which is great. They're going to pay it off and I don't have to make payments anymore. But that also leaves me having to get a new car, and I don't know. And they're like, it depends on the value of the car. We'll pay it off, and if it's worth more than what we have to pay on it, which is highly unlikely, then they'll give me what's left over. So I'm not expecting to get any money back, because obviously cars depreciate in value the minute you drive them off the lot. So the chances of that car being worth more than what it cost when I bought it 2 months after I bought it, slim to none. So
yeah,
because probably
I
won't
think
get
like
extra money.
the statistic is like it depreciates 50% once it drives off the lot.
Yeah, like it's just something retarded like that. And I'm left in the boat where, okay, now I've got to get another car. It's great you paid this one off and I don't have a car payment anymore, but now I have to fucking buy another car. And I don't know how I'm going to do that, because I traded in my last car to buy this one, which is how I got the payment so cheap and had a pretty good down payment. I don't have I can't do that now. I've already traded that car, and I have no car to trade in. And I don't have a large sum of money to put down as a down payment, so I don't know how the fuck I'm even going to get a new car now, which obviously I need for work. For work and taking the kids places. Door dashing was actually a pretty big source of income for me. It wasn't my job, but that side hustle was making almost as much as my job. So I was actually considering quitting my job and just doing DoorDash full time, because I was making so much money door dashing. Like, the area I'm in is super lucrative for DoorDash. I was making on average around $30 or $40 an hour if I could run enough orders quickly enough. Like, I was making really good money doing DoorDash. Now that's all gone. Yeah. And I got to figure out how I'm going to put a down payment down on a new one so I can go back to doing that. It's just, I don't even know how I'm going to get a new car now. All right. So if anybody wants to help out, that would be awesome. I'm monetized on all platforms now. So, clicking those buttons will make me be forever your friend. It'll help me get a new car so I can make more money. And then maybe I can quit my real job and just do DoorDash, which will give me more time to stream too. And I promise, if you guys join the Discord, you donate to the channel, or you subscribe, I promise if you join the Discord, I won't share any of your sex tapes. Okay, I promise, won't happen. I'm not Destiny. We're not sharing sex tapes here. Okay, You shouldn't be posting your nudes in my Discord anyway. You will get immediately banned. But even if you did, we wouldn't share them. Also, I won't steal your content. I'm not Frogan.
Oh, ouch.
Shots fired. It just sucks.
Grenade out.
I don't know how I'm gonna get a new car. This sucks. This royally sucks. Plus, we got no car right now while we're waiting for all this to go through. And the kids have stuff they need to go do. They're missing out on. This is a huge inconvenience because, unfortunately, for some stupid fucking reason, my insurance won't give me a rental car either because I haven't had this car long enough. Apparently, I have to have the car for at least 90 days before it's eligible for a rental car if it's in an accident. So they'll pay for it, but they won't give me a rental car because I haven't had the car long enough, I guess. It's so stupid.
What insurance?
Progressive.
Oh,
Yeah.
okay.
So there you go. They're like, well, you just got insurance on this car 2 months ago, so we can't give you a rental car yet. I'm like, why? My car got totaled within the first 2 months. I'm sorry it happened. If it makes you feel any better, I didn't ask the Amazon truck to hit me. He just kind of did it on his own. Like, it's not my fault. But okay, fine. I guess I don't get a rental car. I just gotta wait with no car. It's so stupid. I've been having car troubles too. Sometimes it doesn't want to turn on. I took it to the mechanic and he couldn't figure out the issue. It was what the issue was after 2 days. I mean, what's it doing? I'm not a mechanic, but I was raised by one. My dad really wanted me to be one, but I absolutely hated working in his shop. And he made me work on all my cars growing up. So when I was 16, 17, you know, when I was back in high school, if my car ever had trouble, my dad forced me to fix it. He wouldn't do it for me. He'd stand over my shoulder and tell me what to do because he was determined to make me a mechanic. But I absolutely hated working on it, and that's probably his fault. He made the act of working on a car a not fun experience that I never want to do again. But that being said, I will give him credit where credit's due. I did learn things. Having to do that myself for so many years, I now know what all the warning signs are. I know what the sounds mean when the car makes a sound. Like, I can identify problems and can probably still fix them. I just don't want to. It does help me when I take my car to a mechanic now, because now I can tell when they're lying to me. And I can pretty much just tell them what the problem was. Like, I had that problem with the Jeep. I remember talking about that on stream where I went there and I told them what the problem was. I could tell what the problem was. And they were like, well, we'll test it and find out. And then I went back, took them, they kept the car for a day or two, called me back. I went back there to pick it up. They said they tested it and it wasn't the problem I thought it was. And I was like, are you sure? Because I'm pretty sure it's that problem. And they're like, yeah. And then I drove it for a month and the problem came back and it was getting worse. It wasn't fixed. It was getting worse. And I told him, I was like, yeah, dude, I think I blew a head gasket. And if I keep driving it with a blown head gasket, I'm going to crack the head. I really shouldn't be doing this. I'm telling you guys to check the head gasket. Well, we checked the head and we checked the gasket and it passed all our pressure tests. I'm like, did you take it apart and look at the head gasket? Well, we're not going to disassemble the engine if we don't have to. I'm like, you have to. I'm telling you right now, you have to. I know that head gasket is blown. For a second time, they tested it and it passed their stupid test.
A compression test doesn't really tell you if the head gasket's blown or not.
Well, they said it was a pressure test, not a compression test. So they claimed it was this state-of-the-art test they had that was supposed to be able to tell. And I'm like, I'm pretty sure it's a blown head gasket. And they tested it a second time, and a second time it passed. At this point, I've spent $1,200. It's $200 every time I have to get them to take the test. They fixed some other stuff. They found some hoses. Like, each time they found a little thing to fix to try to make me feel better, I guess. So they replaced some hoses. They did shit like that. And all this ends up adding up to like $1,200. I drive it for another month, and it starts overheating. And I take it to them the third time, and yes, they confirmed the head gasket is not only blown, but I've cracked the head because I let it overheat because I drove it when I shouldn't have been driving. I'm like, you're the reason I drove it. I told you for the last 2 months that this head gasket was blown, and you guys told me it wasn't. And I warned you that if I continue to drive it like this, I risk cracking the head. You told me it was safe to drive. Don't worry about it. You guaranteed your work. So now I want my money back, and you're going to fix it for free. So that's what happened there. And then I traded the G-Pen because they put a new head gasket on it, but they didn't want to replace the head. They patched it, but I was like, I don't feel comfortable with this. So I went ahead and traded in and bought a new car then. Because obviously once you crack the head, like that's engine replacement time. So you trying to seal the head and put a new head gasket on it, that's not going to last. That's just not going to last. Like, this is replace engine time. Like, that's it. This is game over.
Now, if it was just the valve cover that cracked, okay, that's the part that can get swapped. But the actual head itself?
No, I cracked that. Yeah, I cracked the head. Like, you can try to fill that in, and you can try to seal it, but it's like that's not going to last. So
it's a Band-Aid.
Yep. So while I had that Band-Aid on it and it was working, I took it to a dealership, and they didn't even notice that the head had been cracked on it. So they gave me full value for the car. I was like, I'm gonna trade it in while I can get full value for it. This can be someone else's problem in the future. And I traded it in to get a new car.
Not gonna lie, I did the exact same thing with my Jeep's transmission. My transmission was going out when I traded it in for the Charger.
Yep. Fix it to where it runs, and you know it's going to go out again, and then you take it to a dealership for them to trade it in, because they're not going to take it apart to look at it. They're going to drive it around for a little bit, see how it runs. If everything feels good to the mechanic, and he's like, yeah, it's in good shape, then they'll just give you the full value for it, which is what they did to mine. They drove it for 10 minutes, said it felt good, and then they saw no reason to look at it. I'm sure a month later that became somebody else's problem, and they probably whatever they use to seal that head is eventually going to fail, and then the thing's going to overheat, and the head's going to crack worse, and they're going to have to get a new engine. So I feel bad for whoever buys it after me, but you know what? That's the dealer's problem, because they should provide warranties and stuff for that, and it's their fault for not checking it. I don't feel bad. No remorse. I regret nothing. Ooh, sweet. All right. Anyway, back to this. We've taken enough of a tangent here.
To roll on some motion, so I don't know, but more the case relied on by defendants.
Before I pass the fuck out to get ready to go back to work in the morning.
Yeah. Appreciate you stopping in, man. Got to show up more often.
Good. Have a good night, man.
Later, man.
Supporting the argument is inopposite. In Calhoun v. Invention Submission Corp., the defendant requested that the sanctions be imposed on plaintiff and her counsel for posting the allegations of the complaint on a website. Discovery had not yet commenced, no trial date is scheduled, let alone on the horizon. Here, in contrast, plaintiff has not moved for sanctions, but for a protective order. And two, the defendant has not just posted the allegations of the complaint, but instead has harassed and vilified plaintiff, witnesses, and her counsel, and threatened bodily harm to witnesses. Okay.
I'm pretty sure that the bodily harm they're referencing was when he said that he would kill J-Stock and Queeman if he could, which I'm pretty sure he was being hyperbolic, but you did make those statements. Stop acting like you didn't say that. There are clips of you saying that. You said, I would kill them if I could, and you were very upset. And I'm sure that wasn't a real death threat. You weren't really going to try to go kill them. You did say if you could, though. So I'm guessing that means if it wasn't against the law to kill them, I would. But still, it is a threat. You did make threats. The harassment stuff I don't know about. Maybe they're referencing his community. I don't think he's talked directly to Pxie. So I haven't heard anything about that, whether or not he's actually talked directly to Pxie. So I don't know if you can say he's harassing them if his community's the one doing it, but the death threats he's definitely guilty of, even if they were done in jest.
And discovery has commenced in a trial that has been set, nor is Constant v. Cosby helpful to defendant, since the court entered an order imposing limits on attorney speech. Second, defendant's argument that plaintiff has shown only speculative harm is clearly belied by the record. As detailed in plaintiff's motion and supporting declaration, defendant has publicly threatened to kill potential witnesses. I'd kill them if I could. I want someone to kill named witnesses. Again.
Yeah, that's what he said. So they're quoting him. I'd kill them if they could. I want someone to kill. And they don't want to say their names in the document, named witnesses. He said J-Stock and Queeman.
And Gisticle and Queeman are not witnesses in this case. But as long as Kiwi Farm...
I thought Gisticle joined the case as a witness, though. Like, I thought that happened. I thought I remember seeing him do a stream where he's like, I'm joining the case. And he's now named as a witness on the case. Did he not go through with that? I don't know. I don't watch Gisticle, so I haven't been keeping up with that. I probably should. But I could have sworn that he joined the case as a witness, which is why they could make this filing now that he's threatening witnesses, is because that guy is now a witness. Maybe he wasn't a witness at the time, but I think he might be now. I don't know. I'll look at that after this.
Farms continues to post it. I guess they'll continue to copy paste it. I don't know how long you can just lie about something over and over and over and over and over and over and over again. Maybe this will just be the lie that they carry if they get there all the way to trial. Maybe.
Wait, does he not know that he's named as a witness now? Because you're right, they can't lie on legal documentation. That's against the law. But if they're naming him as a witness, then that should be your... Yeah, that should be like your red flag that, oh shit, Justicle's a witness now. That shouldn't be a they're lying. You should go, what the fuck are they talking about? Jesus.
Who knows? Disclosed plaintiff's legal name in violation of the court's anonymity order. Again, this happened before the protective order came out. Since then, not disclose the person's name.
Right, and if it happened, yeah, again, we can't apply things retroactively. So he did disclose names, but if it happened before the protection order, he was fine to do so. It was public record at the time. Even if they like seal it, even if they're successful in getting this sealed now, you can't hold him accountable for sharing things that were in it before it was sealed.
And clearly the plaintiff didn't really care because they withheld that like the name was in the video for months so that they could have it in a motion, 6 months into the case, I guess. But okay. Published confidential meet and confer communications. Published confidential. I don't even know if these communications are supposed to be considered confidential, but okay. And engaged in...
Did they say confidential anywhere on them? Because a lot of times, I think if they don't say that, which they'll usually put that at the bottom, these correspondence are confidential and not to be shared, blah, blah, blah. Yeah, like they'll put that at the bottom, or private and confidential. If it said that at the bottom and you shared them, then you're in trouble. But you should probably check that instead of saying, I don't know. You should probably go check that right now on stream to show your audience whether or not you did it. Him not checking things, this is Destiny too. For Destiny not to check things, I'm taking as a red flag because this is the guy who autistically like has sources for everything. And he's the guy who always has stuff. So for him to not have something and to not present that is, for him to suddenly just want to talk about things and not show anything is, I'm considering a red flag.
In a pattern of disparagement and ridicule directed at the plaintiff, her witnesses and prospective witnesses, and...
It happens super randomly, but when I try to start it, it'll click like it's about to start, but won't start. Just a clicking like click, 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 click. Does it do that? Is that what the clicking sounds like?
Plaintiff's counsel. I mean, plaintiff has done the same to me. I mean, like when you've made a public Substack that is unhinged and contains like a fuck ton of lies in it, and then you cry that I think that you're a crazy person, like this is just so...
Like it doesn't just click once, but as long as you're holding the key, it continues to click at like a steady interval of click, 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 click. Is that what it's doing?
Ridiculous, but whatever. Plaintiff provided specifics regarding Bonnell's vitriolic public commentary and prospective witnesses' reactions to it. Where? I went through all of the declarations, and I think I only saw one person.
Yeah, it continues. If that's what it's doing, and you took this to a mechanic, and they could not figure that out, get a new mechanic. That is very obviously your starter. Your starter is going out. Because the clicking means that the starter isn't igniting to ignite the engine. It's just clicking. Your starter's going out. That is like the most basic problem in the world to identify. So if you've got a mechanic who doesn't know what that sound is and can't identify a broken starter, you need a new starter and a new mechanic. That definitely, just from your description, that sounds like the starter. But of course, without actually being in the vehicle or being able to, hear it in person, I can't say for certain.
Who said something, but it wasn't even... Yeah.
But if you want to have an idea of what to tell them to check the next time you go there or the next time you talk to a mechanic, tell them, if you act like you know what you're talking about and you give them something to diagnose, then they're more likely to be honest with you. So you just go up there and you be like, hey, it sounds like my starter's going out. Can you guys check my starter and see if it's going out? And then if it's not that, what could it be? Yeah, and you kind of put the ball in their court, but the fact that you already know what the problem might be makes you look at least a little knowledgeable on it, so they're less likely to try to lie to you and take you for a ride.
Yeah, I don't know where these filings are. Somebody can look at it if it's there somewhere, I guess. See ECF 44, 84.1 and 84.4. I guess we can look. 84.1 and 84.4. Plaintiff provided specifics regarding Bonnell's vitriolic public commentary and prospective witnesses' reaction to it. This is 84.1 by Jane Doe. Oh, so this is just Pxie. I'm over 18 years of age. I'm guessing I come to provide testimony. Oh, the personal knowledge. This is so fucking retarded, dude. She's still running with this is just hearsay. This is double hearsay. One of the individuals whose screen name was on the link. When was this filed? I don't even remember when this was filed.
Hearsay can be legal. I don't know why he's harping on hearsay like it's like it's not allowed. Hearsay is allowed in court. It just needs to be labeled as hearsay. It's totally fine to have hearsay. Hearsay isn't like this bad term that you're not allowed to do in court. They just label it as hearsay so the court knows grain of salt. That's it. That's all that has to be done there.
June 2nd. Oh, right before the hearing. So her evidence of people feeling threatened by me are one of these individuals whose name was censored told me that the defendant sent the video depicting me to their sister just a few months ago. This individual and their sister, as well as other individuals who had initially contacted me, completely deleted their accounts after Destiny posted his video on the YouTube entitled Destiny Justice Lawsuit. So keep in mind, just to be aware of what this incompetent part is doing, right, is she's filed a lawsuit against me, and she didn't get statements, declarations, affidavits from any of the accounts that supposedly DM'd her. Like, what the fuck is, how fucking stupid do you have to be? What are you even doing at this point? Why would you not get a single one of these in writing? Why would you not get any names or any statements or verify that any of this information is even fucking true? But then she keeps throwing it over and over and over again in all of her, like, hello? In this video, defendant further violates my privacy by publishing to almost 1 million followers out of context private messages. The 3 women that provided declarations under seal in support of plaintiff's motion for preliminary injunction expressed fear of being publicly targeted or doxxed. This is hearsay. Make them submit an affidavit or declaration saying it. You can't just speak for everybody. That's not how this works, little bro. You can't just say, like, somebody else said this. You have to, they need to sign that. They need to attest to that under oath. They have to sign a thing saying that I promise this is my sworn and true statement, because maybe you're misinterpreting things, or maybe they'd say they wouldn't say that. I don't know why they keep doing this. I know why. It's because it's malicious. This is the actual answer, but the 3 women that provided declarations under seal in support of plaintiff's motion for preliminary injunction expressed fear of being publicly targeted or doxxed by defendant and/or his followers indicated they were unwilling to participate in discovery or testify unless their identities remain confidential. For this reason, the witness declarations were filed under seal. Like, that's not in any of the declarations. But besides these 3 witnesses, there are 4 additional witnesses I have contact with, but they told me that they are afraid of speaking out or testifying against the defendant because of his likely retaliation and harassment. Attached here too, as Exhibit A, is a true and correct copy of one of these witnesses named, who has communicated to me her fear of defendant. Thus, he tried to repeatedly dox one of these witnesses whose screen name is blank after he publicly expressed his support for me. That's not a witness. Somebody who expressed support is not a witness. The potential witness will not testify to pertinent information regarding the case unless his information can be protected. Blank is expressed fear of providing any further information.
They are saying potential witness. So it could be someone who has support for him that has some information that they could use. Oh, God. All these guys do is run away.
Active defendant publicly called for his death on the defendant's YouTube channel. Wait, have I? Or are they talking about on Willie Mack's YouTube channel? I'm pretty sure that was the thing that Willie Mack published of me. I don't think I ever said any of it. I don't remember if I did or not. I don't remember, to be honest. But the 3 other potential witnesses also believe that the defendant has committed crimes against them by exposing intimate images of them. 3 other potential witnesses are your 3 current witnesses. They are afraid of pursuing legal action because of how he's publicly harassed and insulted me and anyone who supported me, including my counsel. 3 of these witnesses have expressed to me their fear that their physical well-being could even put at risk if they attempt to pursue justice. Like, how does this even make sense? If you file it under seal, I still get access to the...
I would blame them because they said they weren't getting the issue. They drove it around and left it running and restarted it, and it was fine. So maybe it just barely started to go out. My dad knows a decent amount about cars, and he also said he doesn't know what's going on with it. I mean, how often does it do it? Like, is it... Because it sounds like it doesn't do it every time, so it sounds like you just got unlucky. You took it to the mechanic shop. You told them that it won't start. And then they started it up and said, well, it's starting up fine. We'll drive it around and listen to it. They drove it around and listened to it. Of course, they're not going to hear the problem while the engine's running. The starter's not engaged. They turned it off, turned it back on, it started. Turned it off, turned it back on, it started. Turned it off, So if they couldn't reproduce the problem, okay, fine, I understand that. But that's why if you go to them and you say, hey, it doesn't do this every time, but sometimes I'll go to start it and it goes click, 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 and it won't start. But sometimes it starts right up and there's no problem. Could you check the starter? I think the starter's going out. It's not completely bad yet. It seems to work for the most part, but randomly it just won't engage. I think it might need a new starter. And now you're telling them the specific thing to check. So they may not have even checked the starter before because they didn't have a reason to. It didn't reproduce the problem for them. So that's why you go in and tell them what you think it is so that they'll check that, hopefully, and then if it's not that, then they'll move on to their expertise and try to find out what it is. Just like when I went in and I told them, hey, I think my head gasket's blown. Can you check the head gasket? And then you've got grounds for a refund and all the stuff that I did if they won't listen to you. Because I told them several times what I think it is. And turns out I was right. But they refused to actually look at the head gasket. They ran tests because they were lazy and they didn't want to take the engine apart to look at the head gasket. They just plugged it up to a computer and let the computer decide. Well, the computer couldn't detect the head gasket was blown. So it passed their pressure test, but pressure wasn't the issue. The issue was when it got hot. And then driving it around for 10 minutes isn't going to make it hot enough to tell if to feel the problems that come from a blown head gasket. But I drive the car around enough that I know what those problems are. I can reproduce them, but they won't listen to me. That's different. Telling them to check a starter, though, I think that would be super easy for them to check. I don't see why they wouldn't just check the starter at that point. When do we get Superman? Superman rewards unlock on July 11th. And then we can get Superman. The new movie. I'm not impressed with the new guy they got playing Superman. I miss Henry Cavill. He was just like the perfect look for Superman. I get that he's from another universe, blah, 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 the Snyderverse. I don't care. Just have him play this version of Superman, too. He can be both. You can say that he's from a different universe and just happens to look exactly like the last one, and have him be a more comic-accurate Superman instead of the grounded, dark universe thing that Snyder did. He's still the greatest actor for the role. I'm sorry, he just is. I haven't seen the new guy, so there. I'm being open-minded. I'll give him a shot. But looks-wise, he doesn't look as much like Superman as Henry Cavill does.
The name. You think I'm willing to have these people like physically attacked? But if you file it under seal, I won't do that? Like, what? Why am I Destiny in the court filings and not Steven or something?
No, they're trying to stop you from physically threatening them in the future. I don't think they think you're going to attack someone. I think they think someone in your audience might be crazy enough to do it for you. And the more you keep saying to do it, the more they might take you seriously and actually do it. That's why. Because you have an audience. If you were a normal person, then this probably wouldn't be enough to get a gag order because you're just a guy talking shit. But you're a guy with millions of viewers on your YouTube channel. You've got, tens of thousands of people watching you every night on stream. So there's a bigger chance that someone might not realize you're joking when you say it and may actually try to take action based on your words. You're held to a different standard than a normal person because you're a public figure.
I think they go back and forth because they're mentally retarded. Almost every individual I've communicated with expressed not only their disgust for...
And I know he knows this because I've heard him say these exact same thing about other public figures in the past. Why he's suddenly now acting like he doesn't get it. Just like it's so transparent. Stop doing this, Destiny. Stop. You're like, there's too much content of you being smarter than this. You can't play the dumb guy. It's not going to work. It's just not going to work.
For defendant's actions, but also their reluctance to speak out publicly due to their concern and fear of defendant retaliating against them. Wow. Wasn't that statement about Disco before they were mentioned as potential witnesses in this case anyway? Yes, yeah. It was like months ago when Willie Mac interviewed me for a YouTube video. Yes. And it wasn't on my channel. It was on Willie Mac's or whatever. Oh, this text message. I'm sorry. I just remember this one. My bad. They did submit this. I just forgot about it because this is the most obviously faked message I've ever seen in my entire life. Stephen Bunnell has abused his position of power and community to gain favor and harass people in the past. I find his actions deplorable and terrifying. I will never feel comfortable being a witness in this case against Stephen unless my identity is protected. I fear for my family, friends, and my current and future careers. Without protection, I am almost certain I will receive harassment and doxing from his community. Nice face. And
yeah, but you can't say the message is fake if that's how they feel. That's the thing about feel statements. If someone says that they're scared to come forth and they're in fear to be a witness, you can't say they're not scared. Neither can a judge. You don't know what scares them. Hey, now, you can say that they're being ridiculous and that's a crazy thing to be scared of. But if they're scared, they're scared. They can just be scared. They can be scared over small things. A lot of people aren't scared of, aren't scared of bugs. But some people... If you show them a bug, you show them a ladybug, they might freak out. Ladybugs, for most of us, are harmless. But some people might have a phobia of that, and they'll be scared. This is why you can't say what's scary and what's not, because you don't know how that person personally feels. So you can't say the message is fake and that this is the most obviously fake shit ever. You can argue they're being ridiculous and childish, and maybe the judge shouldn't take it seriously. But if they're really scared, they're really scared. And some people probably took your death threats to J-Stock and Queeman seriously. Maybe your community has gone out saying a bunch of things based on stuff you've said, and maybe it's not you they're scared of, but they're scared of your community. And your community is going to act when you speak, so indirectly, it is you. There's a lot of ways to interpret that.
And it's the first...
He's not being very charitable here is what I'm saying.
Text message they got from this person. Good one. Okay, so those are the two things that they submitted for evidence of prospective witnesses being afraid. Gotcha. Wait, surely there is some official affidavit from this person that they should have filed instead of this weird written text message screenshot? No, because they don't have any witnesses for this case, because this entire thing is fucking bullshit, and they know it's bullshit, which is why all of this is like either hearsay from Pxie. Oh, it's 1 through 4, not just because it's 81-4 to 84-4. I see. It's just I don't have money for a lawyer or anything. Once he knows my name or something, I'm afraid he's going to harass me or get others to do so. And then, like, what? Jessica doesn't even have any info. What the? What is? He doesn't even have any information relevant to this case. What is the claim that I'm sending him video? Like, we're jerk buddies? Like, what? It's so fucking crazy. But okay. My jerk mate duo, yeah.
I mean, he claims he has information relevant to the case. He's just not going to share it publicly. So you wouldn't know if he had information or not. He claims he does, and you can doubt his claim. That's fine. But he's openly said, I have information, and I'm not going to share it publicly. So if he does have information, him being a witness in this case is when it would come out. And that's He said he's trying to be a witness in the case. They've mentioned him as a potential witness, and now they're telling you not to say things about potential witnesses. So either they're still looking at him as a potential witness, or he is a witness now, and he's, actually joined the case. I can't remember if he said he joined it or not. I know he said he was going to try to. I can't remember if he said he made it official that he joined it or not. I'll have to try to look that up after this.
Contrary to defendant's blithe contention that plaintiff failed to tie her alleged harm to any specific statements or conduct attributed to Bonnell, the evidence presented shows that defendant's actions have caused multiple prospective witnesses to refuse participation and has hindered evidence gathering and thus prejudiced these proceedings. When was my first YouTube video response published? What was the date on that? Wait, I thought there was a YouTube video linked in here. Am I crazy? Is the link just not in a different color? Purpose. Destiny addresses his lawsuit. This is February 20th. That text message was on January 22nd. Had I said anything publicly about this yet? How are my statements in the future scaring defendants in the past? Because that text message that they cited here, first of all, this is just...
I mean, it could still just be based on your reputation. They could be scared of you because of things you've said in the past about other creators. Again, you can't tell them what they can't be scared of. Like, that's still a thing. That's still a thing that they could do, is they could go, well, he has a history of threatening people in the past. He has a history of being scared. Like, I would believe any girl, even if they've had zero interaction with Andrew Tate, of saying they were scared of Andrew Tate simply because of his reputation. So, that could be where they're going with that. He's, again, not being very charitable here. I get why he's not. He's angry, but I think his anger is clouding his judgment a little bit. And he's obviously trying to rally public support for him. That's why he keeps doing this. I mean, it's good content. A, he's doing it for profit, and B, also to rally public support for him.
This was not relevant to this case at all. He has no discoverable. There's nothing relevant. This person said that they were afraid of me on January 22nd. Had I even said anything yet about this? When did Pxie drop her thing on January 20th? Like, they're already afraid? Like, what? Seriously? Okay.
Yeah.
Time moves in one direction. Don't forget. Oh, she's the one that linked my YouTube video on February 20th. Okay. The evidence presented has shown that defendant's actions caused multiple prospective witnesses to refuse participation and has hindered evidence gathering and thus prejudiced these proceedings because they have no evidence, so they have to evidence gather after making the public suspect and after filing the lawsuit in the hopes they're like praying that somebody comes forward with some magical piece of evidence. But okay. This is precisely the kind of conduct that the Gentile standard was designed to address. See also Shepard v. Maxwell. Defendant falsely argues that plaintiff's evidence...
I mean, any evidence they do have is going to come out in discovery. So you can have a problem with the evidence they claim they have and say they're full of shit, and that's fine. But maybe they're holding that evidence close to the chest and not talking about it, because this isn't about the evidence. Remember, this is a request for a gag order. This is about a gag order. This isn't about the evidence. So all of that still might come out later. Just because they're not mentioning it doesn't mean they don't necessarily have it.
Is vague and unsubstantiated.
At least not yet. Like, you're going to know if they have it because you're the defendant. They have to show it to you. But we haven't got to discover yet. Like, we haven't got to that point yet.
And relied on unnamed and or yet unidentified witnesses. This is true. In fact, plaintiff's declaration supporting evidence show that she specifically identified 4 potential witnesses that have communicated their reluctance to participate due to their fear of defendants' doxing and vicious attacks. ECF 85. What is even
I mean, if the argument is that you have a history of doxing people, and that's why they're scared they're going to be doxxed, then it doesn't have to be anything you've done in relation to this case. It could simply be things you've done in the past. That you have a reputation of this, and the reputation precedes you, as they say. Because you're right, time does move in one direction, but your reputation can precede you, which means, it can come before you.
I'm just curious. I should have unredacted versions of these, right? Is that your fault if they're afraid of you? Don't they need to show actual proof that something happened in the testified? Kind of, yeah, it has to be. It can't be generalized. It has to be like specific and traceable or some bullshit.
All they have to show that they're afraid of you is show things you've done in the past that they consider scary because you're a public figure. And again, reputation. So if they can find videos of you threatening people in the past, maybe not them specifically, or maybe not even anyone related to this case, but if they can display a pattern of behavior that the person finds scary, then they can prove that they're scared of you.
Okay, wait, what are these? Hold on. Give me a sec, I'm sorry. Dun, 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 dun. Wait, not this. They sent me, they sent, the versions that they sent me were redacted, so I don't even know personally who these, what the, seriously? I have the same document. Okay. So there are people who are afraid of me, and I don't even know who, okay, based. Absolutely based. Oh, this
would make sense. If they're afraid of you, they wouldn't want you to know who they are because they're afraid of you. That just helps their case. That just proves their point.
It just redacted, so I don't know that one. This is redacted, I don't know that one. Oh, and that message is redacted. Cool. All right, cool. That's good. Based. Okay. So I don't know. I have no further information. I wouldn't be able to tell you guys publicly. It'd be nice to know for my own case. so I could like defend myself, but that's cool. That's fine. I don't have to know any of it, I guess. In fact, plaintiff's declaration supporting evidence show that she specifically identified 4 potential witnesses. What does that even mean? That have communicated their reluctance to participate due to their fear of defendants' doxing and vicious attacks. The names of these witnesses were redacted in the declaration. The evidence submitted in a motion following seal was submitted. Moreover, the 3 witnesses who have agreed to testify and provide declarations would only do so under seal due to their fear of defendants' retaliation. See, but they leaked basically the names for all these people anyway, so good one. Also, I read all of these declarations. I think only one of them mentioned anything about being afraid or wanting to remain anonymous. The declaration of Brooke, she doesn't say anything about being afraid or wanting to be anonymous. That was the first one that was submitted. The declaration of Abby MC, she says she doesn't want her real name revealed, yet they leaked and they keep referring to her over and over again as Abby MC, which is stupid. For document.
I mean, if that's her screen name, that's her screen name. If she's dumb enough to use her real name in her screen name, then she doesn't really have an argument about having her real name out there. If her screen name online is Abby MC, then she can't be mad that everybody knows her name is Abby. Like, I mean, what else are they supposed to call her? They either call her by her real name or they call her by her screen name if they're trying to protect, if she says she wants her real name protected. The lawyers are doing their job. If she says, don't use my real name, use my screen name, and they go, okay, but your screen name's Abby MC. I said use my screen name. Okay, we'll use it. Yeah, like that's fine. Like it is her fault. It does make her look dumb, but you can't really hold that against Pxie and her lawyers.
Entry 49.4. They're not even a witness to this case. I don't even know what this person is doing here. None of the witnesses are even relevant to this case. Like, here's an anonymous witness. I am over the age, or I'm above the age of 18 and competent to provide testimony. I have personal knowledge matters ran, blah, blah, blah. Okay. Beginning on May 25th, 2024, I began exchanging messages with the defendant, Stephen Cabonel, on Instagram, Signal, and Discord, where I engaged in as a fan.
I mean, in a case like this, a witness could be anybody who, had a DM conversation with him or witnessed something he said during a panel or during a DM conversation. If he said something that wasn't public, anybody who witnessed him do anything that wasn't public could be a witness. And you jump into a lot of Discord calls, you jump into a lot of other streams. It could be a lot of people. There's a lot of people that could be potential witnesses, but obviously they have to reach out to those people to be like, hey, we saw you were in a call with, Destiny and so-and-so. And so-and-so doesn't want to speak about what happened in that call, or about what was said in that call, but would you? Yeah, so that's what it means by potential witness. Obviously, the guy you were in the call with didn't say anything or didn't want to repeat what was in the call. He didn't want to be a witness. But hey, there was another person there. Maybe that person will want to be a witness. That's probably what that means.
Shortly after, beginning late May 2024, our conversations progressed, became more personal. We began exchanging private sexual content with one another. Destiny shared graphic sexual content of himself alone, as well as graphic content depicting others, himself and other individuals engaging in sexual acts. Destiny shared some of these videos with me directly via Discord messages, but the majority of them were shared through a Google Drive link, which he sent me via Discord for the first time on or about June 2024. The graphic sexual content he shared with me was mostly digital videos, although some were digital photographs as well. I ceased contact with Destiny on or about November 5th, 2024. I subsequently became aware of the allegations that had been online leaks of Destiny engaging in sexual acts with individuals on or about January 21st, 2025. I became aware of Jane Doe's post on Twitter, where she alleged in part that Destiny shared the videos of them engaging in sexual acts without her consent. Shortly thereafter, I reached out to Jane Doe on Twitter and informed her that I was concerned that Destiny had been sharing private sexual content without consent, stating in part that, quote, back in spring/summer, he had sent me videos of other girls. I assumed that he had consent for these, but I realized he likely didn't. Although I had access to the message between Destiny and myself at this point, sometime afterward, I discovered Destiny deleted the message between him and him in Discord, and subsequently discovered that I no longer access the Google Drive containing the graphic sexual content, which would be deleted. This is like, what is this? This person isn't even claiming that they got anything from me of Pxie, number one, and then number two, they don't even have any context on like, oh, well, I think these other videos weren't okay. Like, what even is this? It's not even relevant to this case. Let's see that.
Okay, I'll give them that one. So far, nothing they said is relevant, and since he deleted the messages, they had nothing they could produce. So I'll give them that one. That one was a nothing burger.
That's one, and then this is their other quote-unquote witness. On or about April 2022, I reached out to the defense team at Cabonel II via Twitter. Shortly thereafter, we get to arrange together in blank where we began a sexual relationship. Thereafter, Destiny and I ran in contact, asking me friendly with his wife at the time, Melina. At some point, Destiny asked me if I was comfortable with him sharing videos or pictures of sexual content involving himself, as well as himself and his wife. I told him that I did consent to him sharing these videos with me. Thereafter, we began sharing pictures and videos of sexual nature with one another. Most of these Destiny for him alone, although at least one of these videos included himself and his wife. On or about mid to late April 2023, Destiny invited me to blank, where he was saying briefly, while at blank, Destiny recorded himself and I engaging in sexual acts, recordings made with my consent, and I authorized Destiny to share the recordings with his wife exclusively. I did not authorize Destiny to share these recordings with anyone else or otherwise make them public. Thereafter, I continued to communicate with Destiny online. In late November 2024, I was harassed by multiple individuals while on Discord who informed me that a video of Destiny and myself leaked online. After confirming this was the case, I confronted Destiny. I don't know if I'm allowed to speak to our. Well, I'm not revealing who this is. So, who told me that he was sorry that any videos involving myself had leaked because of him. Destiny also told me that he only shared this content with a single individual who went by the screen name Rose. I don't believe that's true. Following this conversation, I received messages from multiple women on Discord and Twitter who'd been.
Well, you not believing it true doesn't mean it's not true. And that's the thing, is they said they talked to you about it, and you said you only shared it with Rose, which I'll believe because that's been your story the entire time. You said that publicly. So what does it matter? Like, whether or not you said it to them or not, you also said it publicly. But you need to be able to argue this stuff instead of going, I don't know if that's true, I don't believe that's true. Like, the fact that he's not looking any of this stuff to be like, no, this is what I said, or no, this is what happened, and trying to figure out what this stuff is, he's just reading over it and not putting like any effort into this is it's a huge red flag for me. This is the guy who autistically reads shit. Whose like entire channel, his entire thing is the guy who autistically reads shit and does excessive amounts of research. And now that it's about you, you're like bare minimizing this. Like you're doing it the way that, you know, you complain other streamers do it. I don't know. I'm finding a problem with that. I'm not liking this approach.
Been in contact with Destiny, who told me that Destiny shared with them sexual content depicting myself as well as others. Sometime after the November 29th leaks, I discovered that Destiny deleted messages between himself and I related to the foregoing. So the ironic thing is, and I can bring this up right now, but I won't because I don't want to reveal what it is. They deleted their messages with me, which is funny because we had talked after this and we're still friends after this. And then I looked at my Discord one day and I noticed, oh shit, they deleted all of their messages with me. But I also found out that they were hanging out in a certain Justfield Discord. But also, regardless of all of that, this has nothing to do with this case. What? Like, why is this even here? Like, this person has nothing related to the actual complaint filed by Pxie. This person's not making an allegation. Like, there's literally no point for this even being here. They have so much random. So the fact that they're trying to say that, oh my God, these witnesses are intimidated, they're not even witnesses.
They're related to something, man. This is a court filing under oath. They don't just put random gossipy shit in these. Everything has to tie back to the case in some shape, form, or fashion. I promise you, if her lawyers put it in there, they had a reason. They had a reason, and it will tie back to the case. Or the judge will throw it out. Or get them in trouble. But for you to be able to say that they have so much of it, like, I'm not saying lawyers don't make mistakes and it's not possible that there's some unrelated shit in there, but I don't think it's as, like, everything, like, that can't be the answer to everything. It just can't. Like, no lawyer's that bad. No lawyer's that bad.
These aren't witnesses to this case. These are like literally, these are like random statements that you've collected from people to just throw on that literally have nothing to do with any of this. Like, I don't even know what I can respond to for these. Like, it's not even the subject matter here, but defendant's attempts to ignore or downplay the harm he is causing falls flat in the face of the overwhelming evidence presented. Defendant declared the following about two potential witnesses. Potential witnesses? That's why people like Disco and Queenman, if I could put their balls in a vice and crush them and then feed it to them and then slice it apart.
Those are witnesses who may have been in a Discord call, again, who may have been witness to a conversation of yours. So you know they have the information, but we haven't talked to them yet. They haven't agreed to be witnesses yet. So potentially they could say yes and show up to court. However, they've yet to agree. That's what that means. Why are you acting like you don't know what potential witnesses means?
They're going to kill them. See blank at minute 56:42. When did I even do this interview? I feel like this interview was done in like January or February. Does Willie say?
Yeah, court shit takes time. It's a lot of back and forth, tracking these people down, gathering information, writing up these documents. Yeah, it probably took them a few months to put all this together.
1, this interview was done a long time ago. 2, this isn't even published on my channel. 3, these people are not.
The channel it was published on is irrelevant. It's still you, and it's still public. Everyone from your channel saw it, as well as everyone from Willie's channel and other channels. It was also reacted to on reaction channels. What's your point? Like, that's irrelevant. It doesn't matter that it wasn't specifically on your channel. It doesn't matter if you weren't the one that published it. You did the interview. You knew it would be put on the line. You were obviously okay with it. Like, that doesn't mean anything.
Not parties to this case. These people are not witnesses. They have nothing to do with any of this. And none of my commentary about them here has anything to do with this case. So it's like, it's so fucking stupid. This commentary is not merely uncomfortable or critical, as defendant absurdly claims, but rather violent and extremely prejudicial. This commentary undeniably deters witness cooperation and undermines the fair administration of justice. Both of these people, Queenman and Gisticle, have talked about me incessantly for months after. Clearly, they're not deterred, and clearly they're not afraid. So, like, what are we even talking about here? Like, these people talk about me almost daily.
True. He's got a point there. They, like, Gisticle and Queenman, if those are the people they're saying are scared, I'm not going to buy that. Like, they're definitely not scared. They can't pretend to be scared. Gisticle talks about this almost daily on his channel. Like, it has been... He's right. They won't shut up about it. They have been milking this content cow for a long time. I'll check in on it when there's, like, official court stuff like this to check in on. I'm not just going to talk about it constantly. Like, this is one of those I haven't checked in on it probably since it was filed in February or so. So I figured it was time to check in on it. Let's see where this is going. And it sounds like they want you to shut up. And you're mad that they won't shut up. So far, that's what I've gathered from this.
In another defendant's income-producing streams, I love how they say that, he recently accused the plaintiff and her counsel of fabricating evidence. I love also how we're being honest now. Thank you. We're just taking straight rips from Kiwi Farms. https://uploads.kiwifarms.st data/video/ also their links are broken half the time. So I don't.
You've said this before in the past in defense of Kiwi Farms when it came to other people that the source, and when people have like mocked you as a source when you were talked about in other people's servers, that the source does not matter. What matters is whether or not there was actual truth in what was being said. So it doesn't matter if it came from Kiwi Farms. Is the information correct? Yes or no? That's all the court cares about. Is it factually accurate? Yes or no? That's it. That's all that matters. But you've said that yourself. Like, you know that's all the court is going to care about. So pointing out it's from Kiwi Farms doesn't mean anything. I love how you've defended Kiwi Farms in the past for free speech and blah, blah, blah. And now that the stuff in your Kiwi Farms thread is being used against you, suddenly it's irrelevant. It can't be both, son.
I don't even know. I'm sure the judge will figure it out. Like, actually in clown show that they're literally just control F5ing my Kiwi Farms thread every day for their next legal argument. But that's cool to just waste my time and destroy my life and my reputation and everything else over this. That's nice. Thank God my prior circle of friends is respectful enough, though, to not make any commentary about this at all.
Yep, this is all stuff you've defended Kiwi farmers for in the past and said that you don't care that you have a thread up, that people should be able to make those threads, that it's free speech, and blah, blah, blah. You've defended Kiwi Farms and its right to exist in the past. And now that it's coming back to bite you, suddenly you don't want it there. So which is it? Do you not like Kiwi Farms? Should they not be allowed to do this? Should they not be allowed to post this information? And should it be taken down? Or is it a free speech thing and you're the pro free speech guy? Which is it, Destiny? Can't be both, man.
The other side of it, but only on mine. Very spine possessing people. Defendant tells his hundreds of thousands of followers, I bet this is a fake message, and clearly opposing counsel and plaintiff are dumb enough to fake this in the stupidest way possible. Oh, is that about the declaration that I'd already read? I think it is a fake message. I don't believe it. I don't believe it. And I'll say it again. Put me in your next filing. Defendant has failed to refute the overwhelming evidence consisting of his vitriolic and threatening public commentary, its impact on witness participation, and its actual and ongoing harm to these proceedings. To allow defendant to continue with his unfettered public commentary will jeopardize the integrity of these proceedings and impair plaintiff's right to present witnesses. Saying all of this while even temporarily sealing the transcript where we spoke in front of a judge is the ultimate in cuckoldry, in spineless weaponization of the legal system, and in weaponizing the white woman status to seal the transcript where we're both under oath. And we have to answer honestly in front of a judge. And it's not just the unhinged, deranged, and incoherent ramblings of a schizo lunatic that can apply to either plaintiff or her counsel. Like, it's subhuman behavior. Like, protective order is the least restrictive means. Defendant contends that voir dire, I don't know what that means. Good job.
I'm not sure referring to her and their lawyers as subhuman behavior is going to help your case here. Maybe you should take their advice and shut the fuck up. Holy shit, man.
Voir dire, a preliminary examination of a witness or a juror by a judge or counsel. Wait, wasn't this a public hearing? How can they make it private? It was public. I don't think they make it private. Hopefully the judge should rule against that, but we have to wait for the judge to rule on it. Defendant contends that voir dire.
Yeah, I don't think that the judge is going to make it private at this point. Everything on it is so public now, I don't see why you would seal it or make it private at this point. Unless, like, it being public is having a detrimental effect on the case itself. So, which that would have to be proven. But I've seen no evidence of that yet. What the fuck? I thought I had TikTok set to not show sound. I'm trying to look at my, checking on my TikTok here. I think I have a notification. And my video is getting lots of views and likes. Yay.
That's what he said, right?
Voir dire.
Voir dire. Contends that voir dire, jury instructions, or confidentiality orders are sufficient alternatives. They are not. This case is still in the pre-trial phase, and voir dire doesn't.
Wait, is Destiny saying his Kiwi Farms thread should be taken down? Sounds like he's just saying he hates these people and are using it to attack him. He's saying that it shouldn't be, like, admissible in court and it shouldn't be allowed. Which, if that's the case, then they shouldn't be allowed to post it. Like, he's basically saying, like, they can't use what's on Kiwi Farms because it came from Kiwi Farms. He's knocking the source. He's like, oh, so we're quoting Kiwi Farms now? So we're quoting them as a source now? Like, this should be allowed. And I'm like, well, is what they say in the Kiwi Farms thread truthful and accurate? Like, is it factual? That's all that matters. It doesn't matter where the source came from, because that's like what people say about Ethan all the time when he has something to say about Hassan, and then they go, oh, well, they just got that from DGG, so we shouldn't take it seriously. Like, if the things being said are factual, the source shouldn't matter. But now he's acting like the source matters because it came from his Kiwi Farms thread. So which is it? Does the source not matter? Or should we not be allowed to use that as a source? Which is it? Like, it can't be both. Because when it came to other creators, I've heard him defend Kiwi Farms. Now suddenly they're a source that shouldn't be used.
Nothing to address ongoing harm to witnesses, witness intimidation, and or the risk of future disclosures of confidential material. The proposed order is narrowly drawn, addresses only the harmful conduct already documented, and preserves all rights to file pleadings and argue the case in court. Moreover, all the protective orders governing discovery are standard in cases such as the instant one involving sensitive personal information. Not only did defendant refuse to cooperate with plaintiff's efforts towards a stipulated confidentiality agreement, but he has actually opposed plaintiff's motion for a protective order governing discovery. And although that protective order would serve to protect confidential, sensitive information of the parties, it would not prevent the defendant from continuing his public doxing and threatening and false commentary. Defendant contends that the proposed protective order will somehow restrict or impact his right to defend himself. The narrowly tailored order does no such thing.
The doxing argument, I'll agree with him, goes out the window because she made a Substack first. And it's court documents are public record. Like, if you don't want your personal information out there, then don't sue. When you sue somebody, you have to give your legal name for the lawsuit. And those lawsuits are public record. So you're suing a public figure with your legal public name. You can't be mad at doxing there. That's going to be part of it. Like, that's just how lawsuits work. So I'll give him that one. If Pxie cared about doxing, she shouldn't have sued him. I guess just how that's going to work.
Unless his right to defense involves attacking a threatening plaintiff.
And she definitely shouldn't have made a Substack about it.
Witnesses and counsel. It does not. The First Amendment does not protect speech that interferes with the fair administration of justice. The fair administration of justice. My God. Defendant's attempts to construe plaintiff's motion as nothing more than an attempt to restrict public access to this court is nonsensical. The pleadings are available to the public, and nothing in the proposed order seeks to alter public access. That's literally what a seal does. Or unless you're talking about that's what a protective order. If they're filing to protect names and stuff, that's literally what it does, is to keep stuff off the public record. But okay. Say the judge sees through this bullshit. Is it possible for the plaintiff to be forced to do like a full public retraction or something? No, they would never. I would like counter seal or something like that, or counter seal or something. But the applicable precedent supports the entry of the narrowly tailored proposed protective order, and it fails to distinguish the controlling precedent relied on by plaintiff in their motion. Indeed, the opposition fails to even address or attempt to distinguish the primary case relied on by plaintiff Hernandez, in which the Southern District of Florida imposed restrictions on trial by dismissed speech after finding likelihood of prejudice and no less restrictive means. Defendant's opposition fails to address the critical distinction between constitutionally protected commentary and targeted speech that threatens the integrity of judicial proceedings. You get the vibe that Doe's lawyer hates you personally because she's seen all your negative comments. I think they do because it's a personal friend. That's what I'm pretty sure it's a personal family friend. Particularly through the intimidation or silent.
Well, could that be a conflict of interest? If the lawyer is emotionally or personally invested in the case? I don't know. I mean, he's invested against Destiny, but then on the other hand, any lawyer she would hire would technically be against Destiny because they're trying to, defend her against him, or trying to, claim he did a thing, and they're on the attack against him, and he's got to defend himself. So wouldn't that be any lawyer though? I don't know if him being emotionally involved in it matters. I can't figure out where the conflict of interest would be there. He doesn't have to be an unbiased third party. He has to be on her side. He's her lawyer. So you would want a lawyer who's passionate about winning it, wouldn't you? I don't know if this is actually a conflict of interest or not.
Silencing of witnesses, restrictions on extrajudicial statements by trial participants are both lawful and necessary. The evidence submitted showing the defendant has publicly threatened, disparaged, and
unless you could argue, like his defense could argue and point out stuff in this document that he's going above and beyond what's necessary, and that his obvious bias against Destiny is clouding his judgment and tainting this case in some way. Maybe you could go that route.
and attempted to dox potential, specifically identifiable witnesses, demonstrates precisely the kind of conduct these authorities contemplate. The Southern District of Florida recognizes in Hernandez, when witness participation is chilled by public attacks, courts may impose narrowly tailored speech restrictions as the least restrictive means of safeguarding the proceedings. This motion does not seek to silence one party or prevent any valid defense. It is about protecting vulnerable witnesses from intimidation and ensuring that testimony may proceed from fear or retaliation. Defendant misleadingly claims that this is a low-profile civil dispute. Opposing thing, page 11. It is not. I wonder what this was in the context of. I mean, it's a civil case. It's not like a huge corporate...
I think that they're arguing about the low profile point of it, as you downplaying how big you are as an influencer. Because you're right, it's not like a nationwide news story like a big corporate case is going to be. But you also can't pretend like it's calling it low profile makes it sound like you're just another average guy in an average lawsuit like a normal person. And you're not. You're an influencer. Obviously, you're going to have more eyes on this than if, John Smith and Jane Doe were to sue each other and like no one cares. Just Joe Blow were to just your average Joe is suing a person. Like, that's different. So it may not be as high profile as like a corporate case, sure, but it's also not low profile. I'd say you're probably mid to somewhere slightly above mid. I mean, you've got a pretty decent following. You're a pretty famous guy. You've been on Piers Morgan. You've gone on TV. Yeah, you're a much larger influencer than most.
Litigation thing, and it's not a criminal case, but there have been numerous press releases and articles about it, and hundreds of thousands of people tune into defendant streaming platforms to hear his distorted version of the proceedings and allegations as I just read the court documents, but okay.
You're not just reading them, though. You are commentating on them, as you're doing right now. You're reading them and then interspersing that reading with your commentary. So they're arguing that the things you're commentating on and the things you're saying about the stuff you read is what makes it inaccurate. Why are you acting like you're not adding commentary to it? You're doing it right now.
And to listen to and encourage with financial remuneration is abuse of the plaintiff, her witnesses, and her counsel. They keep bringing this up over and over and over again, despite the fact that I've lost money on this. And they know that too, because that was also part of our hearing, which is probably another reason why they want to keep it sealed. Do you think this woman could have had law school paid for what this woman said? I think she already took the LSAT one, so she probably took it and got like a 70 on it and was like, me, we'll just play lawyer instead. This is not the run-of-the-mill civil dispute, but rather a high-profile dispute with lurid content and a trial participant, the defendant, who has his own streaming platforms with almost 1 million followers. This scenario only exacerbates the high-risk approaches to these proceedings due to defendants' threatening, harassing, and false commentary. Plaintiff's limited public comments do not warrant denial of the order. Defendant argues that plaintiff's own public statements undermine her request. This is false. Equivalence. Plaintiff's posts consist of announcements of procedural rulings, for example, sealing of witness identities, a fundraising effort. Defendant should certainly not object to plaintiff's GoFundMe page. It's a Give, Send, Go page. Got him. Since he has been profiting immensely from this case by streaming on a regular basis about it.
True. You're doing it right now.
My lawyer's fees are up to about $200,000 so far. I have not made that much money talking about it.
It's not about how much your lawyers cost. Stop obfuscating. It's about how much money you made from talking about it. That's all that matters. Your lawyer bills don't change whether or not you talk about it. The amount of money you're making on stream might, and that's the point that's being made, is the amount of money you're making on stream is what's changing because more people are watching your stream because you're milking this controversy as content. If you didn't have this to do as content, maybe less people would watch you. We don't know for sure, but maybe. The one thing we know for sure wouldn't change, even if you stop talking about it, is the amount of money you're going to owe your lawyers.
Of this case, not to mention canceled shows, reputational harm that will likely never go away, and everything else involved in this, but that's cute.
Okay, he's got a point there. I mean, him having reputational harm just from the allegation where he's not been proven guilty yet, that's a good argument, but you're also helping to promote that. You're also not helping your reputation by constantly talking about it. The more attention you bring to it, the more harm it's going to do to your reputation, even if you think that attention is you defending yourself.
Cute to say this over and over again. They really, really, really like to run with this argument. His profit revenue is evidenced by the number of views on his videos about the case and the number of comments and questions. For example, streamers such as defendant receive revenue from their YouTube channels based on memberships, AdSense revenue. Streamer gets paid based on number of users doing ads, and super chats. The user pays to have his or her message highlighted in the live chat during a stream. The more money is paid, the more likely the streamer will read the message aloud or respond to the question. A fundraising.
True. That's how super chats work. That's how donos work. Nothing they said there was wrong.
In general, calls for information relevant to her case or witnesses. Again, I'm sorry, little bro, but if you want to be a big boy or big girl and you want to be an adult and you want to file a court case, then you should file the case with your affidavits and everything in hand. If you're filing a case with nothing on pure lies and copium, which is what she's done, and she knows that she's done that, and then you're praying to God that after attacking my reputation as hard as you can, after going after everything I have as hard as you can, praying that somebody comes forward to substantiate your bullshit case, that's on you for being sorry. CCF 992 to 95 and start.
Have they said they don't have witnesses, or have they? I mean, using the term potential witnesses doesn't mean necessarily they don't have witnesses. They seem to want to protect the identity of those witnesses, so they call them potential witnesses instead of naming them. So it could mean that they do actually have the witnesses and they're going to come forward when the time is needed, or maybe they're trying to find a way for them to come forward without revealing the identities of the witnesses. That's also a possibility. I mean, acting like they have nothing, I highly doubt they have nothing. I don't think you would have to be an astronomically stupid lawyer in order to completely file a case with absolutely nothing, with no merit to file a case on. I don't think any lawyer would do that.
Contrast the defendant, none of plaintiff's posts involve threats, harassment, vilification, saying that I lying about her age over and over again, saying that she was 19, saying that I purposefully wanted my sexual content to be leaked and spread all over the internet. All of that, none of that was vilification. Seriously? Exposure of sealed identity, and again, it wasn't sealed yet. It was the same day, but. Or publication of confidential materials. I don't know what they're even referring to there. Plaintiff has not doxed, intimidated, or mocked any party or witness. There is no evidence that plaintiff's limited posts have deterred witness participation or jeopardized trial fairness, while there's ample evidence that defendant's posts have done so. See above. Further declarations of people that aren't even relevant to this case based. Defendant distorts the request for relief by arguing that the protected order would allow plaintiff to broadcast her message while sound position, but it is patently clear that the request for relief would apply equally to both plaintiff and defendant.
I'm going to say, just from hearing he's reading it and the way he's doing this, it does sound astronomically stupid to be reading this stuff, especially when the entire nature of this document is that you talk too much, and the fact that you talk too much is why we don't want to name witnesses and stuff, because we know that you'll read them out to the public or that you'll expose them when they might not be exposed. And true, it's a public court document. Anyone can go read it, but they would argue not many people would actually seek out the documents and read it, but hundreds of thousands of people will view your videos and get that information that otherwise wouldn't have it. And the judge could go either way on that because, yeah, the judge could just go, well, I mean, it's public record, so he's free to read public record. Or you could get a judge that's sympathetic to that to go, well, you did read that public record and shine a bullhorn on it, so it's clear that you just didn't want that information to be available to the public. You wanted to make sure the public got it. That shows intentionality. So, God, I could see that going either way, which is why it's stupid for you to keep talking about this. Because this isn't like you're not 100% in the right, which means you could be shooting yourself in the foot by accident right now. You're not as blatantly stupid as like Casey Trons or Denims, but I still think this isn't smart.
Seeks only to silence threatening, harassing, and false commentary. See ECF 845. I forget. Did their thing allow them for her to keep her stupid GoFundMe up, her GiveSend up? Is it just me, or does this feel like it hinges entirely on the premise that you leaked everything to Kiwi Farms intentionally, despite you being the one most regular? Yes, it does. I think that's one of the overarching narratives that kind of got destroyed at the hearing, which I think is one of the reasons why, another one of the reasons why they wanted that transcript sealed. And it was funny. This was one of the things I was like happy about. Is
wait, did they say that at the hearing? Did they say that they think Destiny leaked information to his Kiwi Farms thread on purpose? I don't remember that being said. Did they actually say that?
I could see the because the judge kept asking questions where he's like, wait, so he published that to Kiwi Farms? And then she's like, well, no, someone else. And he's like, oh, okay. Or when she was talking about when I found out that she'd sent all of our videos to her ex, and the judge was like, wait, he sent all of your guys' videos to your ex-boyfriend? And then she's like, no, I sent our videos to my ex. I was like, oh, like he was like I could see the lights turning on the judge, and he was like, wait, what? Or like this, wait, really? But hopefully we can read the transcript soon. Prohibited content.
Yes,
harasses, threatens, or
transcripts.
publicize.
It's kind of what I thought this was. I thought this was transcripts, but it's not. Would rather get your ass eaten by Destiny or BJ from Hassan? Probably the BJ. If I had to pick. Probably the BJ. I don't know. Getting my ass eaten sounds weird and super gay. You know, if I'm getting the BJ, I can just lay back and pretend it's a girl. I don't have girls eat my ass, so I would not be able to not think about the fact that that's a man eating my ass right now. I don't. My wife don't eat ass, so yeah.
Repeats any sensitive personal allegations or private details underlying the claims. Publicizes or repeats any confidential settlement discussions or communications. Federal Rules Procedure 408. You're gonna have. Wait, is this?
Plus, I've heard the reviews of Destiny's sex tape. From what I hear, he's pretty bad at BJ's. He's pretty bad in bed, so I think maybe Hassan will be better at it.
Even real? Protective order, and part of it is misrepresents or mischaracterizes the content of legal filings. What? Rule 408, compromise offers and negotiations. Prohibited uses. Evidence of the following is not admissible on behalf of either party, of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistency or condition, furnishing, promising, or offering, or accepting, promising, a valuable consideration, a compromise, or attempting to compromise the claim, and conduct or a statement made during compromise negotiations about the claim, except when offered any criminal exceptions. Wait, what? I'm sorry, am I not understanding this? This federal rule of civil procedure sounds like it has to do with whether or not, like, things that you say during negotiations for like a settlement are admissible as evidence towards the validity of the claim or whatever. This doesn't sound like it has anything to do with protecting communications. Am I looking at the correct Federal Rules of Civil Procedure 408? Compromise offers. Okay, I'll just keep reading. I'm sorry. As a matter of general agreement, evidence of an offer to compromise a claim is not receivable in evidence as an admission of, as the case may be. Okay, yeah, this makes sense. So like, for instance, if I like, this makes sense. Let's say that I'm like, okay, let's settle. Let's have a discussion, right? We've had discussions on settlement. Oh, I'm leaking more information. Let's say that I was to say, okay, fine, I'm going to settle. I'll give you X dollars. You know, we make a statement.
Yeah, you were leaking more information. I don't think she's mentioned that y'all have discussed the settlement. Are you going to say what the parameters of the settlement you discussed were now? Are we really just going to gloss over that? Yeah, that is new information. True. We all know how experienced Hassan is. Yeah, he sucks.
Or whatever, and then that's fine, right? You're like, and then they're like, no. And then let's say that like later on in the case they file, and by the way, I know that he's guilty of this because when we were having discussions of settlement, he offered me X amount of dollars, right? That's what it sounds like Rule 408 is governing. Not like evidence, like you can't submit evidence to prove or disprove the validity or amount of a disputed claim based on the settlement discussions. As with evidence of subsequent remedial measures dealt with in Rule 407, exclusion may be based on two grounds. One, the evidence is irrelevant, since the offer may be motivated by a desire for peace rather than from any concession of weakness position. Two, a more consistently impressive ground is promotion of the public policy favoring the compromise and settlement of disputes, whether rules ordinarily phrased in terms of offers or compromise. I'm sorry, okay. This is why I don't reading their citations is painful. I don't know why this was cited here. Sorry, 20 years.
You should read the citations. It tells you where that information is coming from and why. It seems pretty important.
Mandami has said that he wants the city to run supermarkets. Do you agree that it's idiotic? The profit that capitalists make on supermarket products already low. Thinks capitalism will not bring down prices. I mean, yeah, personally, I think it's a dumb.
Especially when you're the thing they're citing.
But I mean, we'll see what happens. But remember that they described this order as incredibly narrowly tailored. So they're saying this is a narrowly tailored order. And the order is No person covered by this order shall make or cause to be made any public statement, including on live streams, podcasts, social media platforms, blogs, or to the press that disparages, harasses, threatens, or intimidates the parties, witnesses, potential witnesses, or either party's counsel. Oh, okay. What does that even mean? What is a potential witness? Like somebody named in the like pre-trial disclosures? Publicizes or repeats.
Someone who they know has information that they could use, but hasn't agreed to come forward yet. Someone they're probably in contact with and trying to talk into coming forward, but hasn't agreed yet. That's a potential witness. I don't know why you're acting like this term is so fucking confusing to you. You're smarter than this, Destiny. I don't buy it. I don't buy it. The more he says it, the dumber, like the less I buy it.
Any sensitive personal allegations or private details underlying the claims of the action. What does that even mean? I can't even talk about the subject matter of the court case? Like, publicizes or repeats any confidential settlement discussions or communications which are protected, they're not protected by this, or any meet and confer communication with counsel. What, so I can't bring up the fact that she was, what, threatening to herself if I didn't pay her off? Or that they were asking for $15 million from me?
They specifically said confidential. They specifically said confidential or protected. Was that confidential? I'm pretty sure they're talking about any paperwork or things they send you that are labeled as confidential.
Initially?
That's what I would take that to mean.
Publicly identifies the plaintiff or witnesses whose declarations have been filed under seal, or speculates about the identity of witnesses or potential witnesses, particularly in derogatory, demeaning, or inflammatory
he's driving
terms.
my car.
So I can't even say if I think somebody's lying. I can't say that like the allegations against me are false. This is not true. What? Misrepresents or mischaracterizes the content of legal filings, discovery, court orders, or the position of any party or attorney. Wait, what the? This is supposed to be narrowly tailored. This is basically a 100% gag order. Like, so I just can't say anything at all about the case anymore. Like, that's basically what this is looking at. To call this narrowly tailored is insane. But okay. Okay, sorry. That was the first meme. And then the second meme is, I think we filed to have the one the Abby MC shit completely tossed because it was just for, I don't remember. I don't remember. It was a ridiculous submission. But is that their proposal for a gag order? Basically, yes. They call it a protective order. That's basically what it was. Plaintiff Jane Doe's reply in support of motion to file redacted evidence in support of the declaration of Abby MC and for leave to file under seal. So first of all, when they filed Abby MC's declaration, they should have attached the evidence to it. I don't know why they didn't. They probably didn't even have it at the time because they don't give a fuck if any of the people talking to them are even making real allegations against me or not, which is evidenced by the fact that they were relying on DMs from people whose identities they hadn't even ascertained before filing the complaint, and then groveling in front of the judge for a temporary restraining order 2 months after filing the case.
Of course, some other dude
and then trying to blame their cancer treatments on their late filings. It's so ridiculous. Don't take the fucking case. If you can't balance chemo and motions at the same time, why you like? I don't even know if you're competent to practice at that point. But whatever.
True. That shouldn't be held like against you that the lawyer decided to take on a job while he was in the middle of cancer treatments. That should be held against the lawyer there. I get it. He's probably doing it to try to garner sympathy, but that does sound like, well, if you weren't fit to do the job, why did you agree to take the case? So he's got a point there. What the fuck?
Whatever. Defendant's attempt to strike the evidence corroborating the declaration of Abby MC reeks of desperation. The evidence corroborating? This is not a corroboration. This is her initial claim that should have been included. It's not corroborating evidence to include a text message. Also, by the way, just to be clear, this is the evidence that she submitted to that she gave to the attorneys. By the way, Destiny sends me sex tapes all the time, and he thinks, I don't know, the girl's in them, but I have videos of him being Cherry and Pxie, like Limfeo. He just sent me another one. Haven't opened it. Let's see who he's seeing this time. He should be more careful, basically. Limeo. This is the totality of the evidence that this person has that I've ever sent them anything, which I haven't. Because another thing they admitted in the hearing that they said very clearly, I think on 2 different occasions, was this person never gave them any evidence whatsoever that I actually sent her anything. There was no evidence of that ever submitted, ever. They admitted that they hadn't seen evidence of it at all. And I also know this is the person who I showed was apparently taking pictures of my computer when they were at my house. So I don't even know what they've seen or haven't seen on my computer or what, because like this video doesn't even exist. This isn't even a real thing. This is not even a real thing. Also, I like how they also edited part of a redacted filing too. What, you couldn't redact the person's message, but this is the totality of evidence that this person has. It's like this, in case you're not aware, this is the one thing right here. This is the entire case is built on this one message. The entire motion for summary judgment that we're filing, right, on whether or not the case will get tossed, whether we have to actually trial, all of it will come down to whether or not the judge thinks that this is a factual dispute that would need to be settled in a jury trial. It will all come down to this one singular message. I don't know how judges ordinarily rule on evidence stuff like this, but y'all should depose Abby MC, you mean? Because I don't know who the other person is. Yeah, maybe if it gets up from me, we'll do a deposition. Does the judge differentiate between loaded words and their actual meanings, like when you say corroborating? Oh, I don't know. I'm just saying that like they're acting like they're submitting more and more evidence that's corroborating this person's statements, but it's not corroborating evidence. This is just the text message that they referred to in their first declaration. It should have been submitted with her declaration, but I don't know why they didn't. I thought you tried to serve them and it couldn't be found. Yeah, we're trying, but that text doesn't even prove you sent the Pxie one before October 2022. You mean after? Yeah, no, it doesn't prove anything. And like I said, I've gone through my messages with this person, and I haven't done. It's just not true. The person's lying. It seems like there's just an endless back and forth of filings between plaintiff and defendant. When is it going to be ruled? Well, these motions should be ruled on soon, and then hopefully we get something from the magistrate judge soon relating to the preliminary injunction. But like judges are busy; they're not going to be like proofreading every single motion or going through all this. But, yeah. Do they need proof of this part of the trial? Well, I mean, you could argue that their proof is her testimony. right? The proof would be her saying, he sent me those videos. And so, I mean, if it was a very conservative judge, again, I don't know what the standards are, like the strict standards are for summary judgment. Like an incredibly conservative judge, I guess, could theoretically rule and say, well, this is a material fact dispute, and it's not up for the judge to make a ruling on that. So then the entire trial would basically be putting Abby on the stand and then having her testify. But she must agree to be deposed and answer any questions before MSJ. Oh, motion for summary. Oh, maybe that's true. Maybe she refused.
Yeah, she may have refused being deposed because she's trying to protect her identity, even though her screen name is Abby. Look, I think the Abby thing's stupid. People already know who you are at this point. You just need to say it. So, like, either you're going to be part of the trial and you're willing to come forward, or you're not. It can't be both.
Refuses to be deposed, then maybe it gets tossed, I guess. What reason? What would be the reason for you to not show publicly all the DMs with this person? Because technically, why not? Wait, was there a reason for this? Oh, I don't know if it counts as like revealing the person or whatever. So I don't even know if I would need to. Also, I'm not dumping my whole DM history. It's fucking gross. But I mean, like I said, like I went through and I looked at the particular date, and I know which 2 videos I was talking about. Both of them refer to. I know exactly which 2 videos were, and it was nothing to do with this complaint or any of the people involved in this complaint. It's nothing related to that. Like I know exactly what they were when I was referring to on that date. And this person probably should know as well. Like you can even tell by reading their responses to me that they know what it was. So this is just it's a total fucking. But I think this person is. I could say a bunch about them, but they have their own set of problems. But. Defendant's attempt to strike the evidence corroborating the declaration of IMC reeks of desperation. See defendant's opposition for months. The defendant has been gloating on his platforms to his hundreds of thousands of followers that despite his heinous acts, he will not be held accountable.
W's in chat. All that movement bullshit just got you killed, brother. Woo! This is fine. This is fine. He's purposefully acting retarded to play victim. Yeah, and he's not very good at it. Like, you've got way too much content in the past where you're analyzing other people's court shit, and you're way smarter than this, and you point all this stuff out. You clearly know how the legal system works, and you suddenly acting like, wait, what's that mean? What's this mean? You sound like Jordan Peterson during that Jordan Peterson versus 20 Atheists thing where you made fun of him because he's going on and on about, well, what do you mean by truth? What do you mean by question? What do you mean by person? And he's acting like he doesn't know what words mean. Yeah, you sound like that now. Everyone knows that you know this court stuff. This isn't helping your case. I don't know why he's doing this. I don't know why he thinks he'll get away with this. I don't know why he thinks this will help. Like, either you're going to properly analyze this stuff and you know, turn it into content and say, hey, I know that this looks bad, but I think my defense is this, this, and this. Or you don't want to talk about your defense because you don't want them to know what it is until you get to court, in which case, why the fuck are you talking about this at all? I don't know what this is or why you're doing this. I'm just here to get the, like, information that's in the document, and he's the only one I could find that's reading the document. But his little commentating, during it just makes him sound like a retard. And that doesn't work because people know you're not retarded. You're not Denims. You don't have a history of saying dumb shit. You clearly understand this stuff. To pretend like you don't is ridiculous.
Because he allegedly shared the video prior to the effective date of Cardi. No! I have not said that I think anything wrong happened or that anything was done, you know, non-consensually, whatever. That would be an argument that we could have if they have subject matter jurisdiction. But the first argument we're going with is, of course, is you're trying a case that you don't even have the authority to file in federal court. You chose to file in federal court, and you chose to file under the statute, and you chose to deliberately lie in the filings. One, claiming that you had evidence from people that didn't exist or that you hadn't gathered evidence from, and two, by lying and misstating the date of a submitted text message in order to bring it in rank so you could file this in public court, in federal court, so that you could have your fun day parading around on the internet like you meant something. So that's on you. Sorry. Indeed, to date, defendant's entire defense has hung its hat on this alleged lack of subject matter jurisdiction. That's wrong, and that's a lie. But I can't read the court transcript where we talked about this in front of the judge, so I guess you got me there for now. But despite defendant's harassing and threatening commentary intended to prevent witnesses from coming forward on plaintiff's behalf, a brave witness did come forward and provided a declaration evidencing that defendant shared the video with her after the effective date of Cardi, thereby defeating defendant's only defense. Okay, that's not my arguments, but even without the IBMC testimony and evidence, however, there are strong legal grounds for finding subject matter jurisdiction under, inter alia, the ongoing distribution doctrine. So there's another Kiwi Farms argument where they're saying, well, if you send a link to a thing, technically you're always continually and forever sending it. But again, my counter argument there is that means that every single thing you ever send ever is always being continually forever sent. That would be true of every single digital platform ever, which is stupid. I've never seen a court case.
I'll agree with him on that. To say that it is being saying that it is being perpetually sent because you shared it on Google Drive, and that Google Drive link is still active, so as long as the link is active, it's being sent. No, if he's not actively sending the link to people, then I don't think that should count. Yeah, I do think that's stupid. So I'll give him that one for a call out. That is not kind of. It is that argument is ridiculous.
Ever that uses this standard to determine ongoing distribution, but they're welcome to cite one if they can find it. Although actually, I think in the hearing, I think they admit.
I believe ongoing distribution has to be like it's a published work, and it is ongoing because as long as that publishment is available and searchable and people can find it on their own than it is ongoing. If you send a private Discord or a private Google Drive link to somebody, then you're not perpetually sending it because they still have that link and they can send it to other people. Like, that's not how that works. However, if you published a publicly accessible Google Drive link on your website or on a blog or in a comment or a description of one of your videos, then they could make that argument.
Admitted that they had zero case law to back that claim up as well. Defendant's opposition relies on false and misleading statements, a mischaracterization of the evidence, and inapplicable case law in its futile attempt to strike the corroborating evidence. The very premise of the opposition is false. The evidentiary hearing on plaintiff's motion already occurred. Now, on the eve of the court issuing a ruling on her motion, plaintiff seeks to submit new and untimely evidence in support of her motion, depriving Bonnell of an opportunity to respond or to challenge the declarant in open court. The actual facts are that 1, IBMC's declaration was submitted on May 2nd, 2025 in support of plaintiff's reply to opposition to motion for preliminary injunction. Yeah, but not her actual text message. How are you?
Okay, so they're directly addressing stuff he said on stream and stuff to be like, these are the actual facts, he's misrepresented.
You allowed to talk about stuff in the hearing when it is sealed? I mean, it's just the transcript that's sealed. I should be able to talk about the hearing. I mean, I was there and it was public. It was a public hearing. The only thing that's sealed is the transcript. 2, the declaration specifically referenced and quoted a text chat thread in which IBMC told her friend that she had just received a sexually explicit video of plaintiff from Bonnell. 49-2. I don't even remember what her original thing looked like. Wait, does it quote anything here? I told my friend that Destiny sent me another video of him and another woman that I recognized as the streamer with the screen name Cherry. That's not even what she said. It doesn't even match the what the additional stuff that she filed. She said that I told my friend that Destiny sent me another video of him and another woman that just another person. So she doesn't even accurately summarize. I'm not going to say anything.
So she didn't name that person before, and now she's naming them. So that's the only difference. Maybe that person was fine being named now, but wasn't before. Like, that could be the argument there.
Or whatever. Maybe the like her affidavit here doesn't even match the text messages that she submitted. But okay. The declaration specifically referenced and quoted a text chat thread. I don't see any quotations here or quote marks, unless I'm missing something. But okay. Maybe quoted means something different to them. The evidence is not new, but rather is evidence corroborating ABMC's declaration in the form of a screenshot of the referenced and precisely quoted text chat thread. The evidence was submitted before the June 3rd preliminary injunction. I like how they don't put the date that they submitted this evidence, but they do put the date they submitted her original declaration. The June 3rd preliminary injunction hearing, by the way, the evidence...
Do they have to put that? Like, I don't know which one they're legally required to put.
So they submitted of her corroborating text message was on June 2nd, by the way, but okay. Good one. What is the... Wait, was this? Sorry. What was this? Sorry, it's annoying because like it seems like I'm being a stickler here, but remember, this is the only piece of evidence that is keeping this case alive. They know it. This is why they are desperately trying to salvage what they know this is alive. They're desperately trying to salvage this. And it's just irritating that they're not even summarizing their own evidence correctly, right? So they say that the declaration specifically referenced and quoted a text chat thread in which IBMC told her friend that she had just received a sexually explicit video of plaintiff... Wait, did I just misread this? Okay. The declaration specifically referenced a quoted text chat thread in which IBMC told her friend that she had just received a sexually explicit video of plaintiff... Oh wait, no, even this is not correct.
What?
I don't even know what the fuck I'm reading anymore. I'm sorry, hold on. The declaration specifically referenced and quoted a text chat thread in which IBMC told her friend that she had just received a sexually explicit video of plaintiff from Bonnell. So that's not true. She says, by the way, Destiny sends me sex tapes all the time, and he thinks I don't know the girls in them, but I have videos of him fucking Cherry and Pxie, like Limfeo. He just sent me another one, haven't opened it. Let's see who he's fucking this time. So this text...
You think that's why he likes reading this stuff out? Because he likes humble bragging about how many girls he's banged, how many other streamers he's banged? Like, you think that's what he's doing here? Because that's kind of how it plays off when he gets to sections like this, and that's obviously the nature of the case, is he's bragging like, yeah, I do this with a lot of girls, so why are you acting like you're special? God, that's kind of how this reads to me, man. It's just humble bragging about the fact that, yeah, I'm that streamer that fucks a lot of other streamers.
That they're summarizing here doesn't even accurately summarize this, number one. And then, number two, her declaration doesn't even match her own text thread here, because she says, on or about November 3rd, I messaged a friend of mine and told him that Destiny had sent me the above-mentioned sexually explicit video of himself and another woman, and that I had recognized the woman as the streamer Pxie. I also told my friend that Destiny sent me another video of him and another woman that I recognized as the streamer with the screen name Cherry. I was able to recognize Cherry just by her voice, and since the video was a black screen with audio of the interactions, I retained in my possession a copy of them. But that's not even really what she said here. She said that I had sent her tapes of Cherry and Pxie, and then I sent her something different this time. So her own declaration doesn't really match the submitted text message here, the two messages that we see with no other context around it or anything else. I have no idea who these are to or what this is in reference to. And then their summary doesn't match their newly submitted evidence, nor does it even match her declaration. Okay, sorry. Anyway, but whatever. The evidence is not new, but rather is evidence corroborating ABMC's declaration in the form of a screenshot, blah, blah, blah. The evidence submitted before the June 3rd preliminary injunction hearing 2 and 5. Bonnell could have subpoenaed Abby to testify at the hearing, but he did not, thereby waiving any objection to her declaration. I think we've tried to subpoena her, but we can't get a hold of her. Like, they're not accepting service on her behalf, and we can't find her anywhere right now. So, okay. The evidence at issue is not new and was timely submitted. Defendant mischaracterizes the corroborating evidence submitted as new and untimely. In reality, the text message plaintiff seeks to submit was explicitly referenced in paragraph 7 of the declaration, but it wasn't explicitly referenced. There are no quotes. There is no quotation mark here for anything. This is at best, it's a summary of this message. It doesn't even match the content one-to-one of the message. And again, we're in a court case, so it's kind of important that you're being specific with your words. So, whatever. which was filed on May 3rd, 2025, well before the evidentiary hearing held on June 3rd. The evidence is therefore not a belated submission, but rather documentation corroborating a declaration already in the record. Courts routinely allow such corroborative exhibits, especially where they support previously submitted declarations and relate directly to evidentiary matters under review. Unlike in Butler v. Garland, plaintiff is not attempting to reopen the evidentiary record or offer post-hearing supplemental declarations. Instead, plaintiff merely filed They keep calling it corroborating when it, but oh, whatever. Material reinforces previously submitted evidence already before the court, all filed prior to the hearing, the day before the hearing. Defendant's reliance on Butler is misplaced and said has no relevance here. IBMC's declarations and corroborating was submitted prior to the hearing. Ironically, on May 30th, defendant objected to IBMC's assertion in her declaration that defendant sent her the video because she provided no support for this baseless contention and failed to attach any exhibits reflecting the alleged transmission of the video. In response, plaintiff submitted the corroborating evidence of her text message. Why wasn't that included with the original filing? Number one. And number two, there's still nothing that has to do with transmitting any videos to her. But defendant further argues that because plaintiff had notice of a jurisdictional challenge, the evidence had to have been presented at the hearing or else risk waiving the right to present such evidence. This, of course, is nonsensical because the court never said it would only consider evidence presented at the hearing. The briefs and supporting evidence submitted prior to the hearing are also part of the preliminary injunction record. Also, neither of the cases rely on...
It's true. Evidence comes out in discovery. They don't have to present all of their evidence at the hearing. The hearing is not discovery. I like how he glosses over that part. The judge didn't say present all your evidence now and they don't present it during the hearing. You can't be like, well, they can't bring that as evidence now. They didn't do it during the hearing. No, that's what discovery is for. Again, things I know you know. I've heard you accurately talk about how the court system works in the past.
Defendant's contentions that the evidence is new and untimely. Defendant's evidentiary objections like merit. Defendant argues that the corroborating text messages is inadmissible hearsay and unauthenticated. However, such evidentiary objections are premature and misapplied in this context. The court may consider hearsay in preliminary injunction proceeding, particularly when it supports testimony already presented via declaration. Preliminary injunctions are customarily granted on the basis of procedures that are less formal than evidence that is less complete than any trial on the merits. All well-pleaded allegations in the moving party's complaint and uncontroverted affidavits filed in support of the preliminary injunction motion are taken as true. Uncontroverted, meaning we don't contest them, no? Isn't that what uncontroverted means here? Furthermore, in reviewing a preliminary injunction motion, a district court may rely on affidavits and hearsay materials, which would not be admissible evidence for a permanent injunction if the evidence is appropriate given the character and objectives of the injunctive proceeding. Did the magistrate judge say anything in the hearing about the fact that Jane Doe submitted these exhibits on the day before the hearing? No, we read it a couple times, but they kind of stayed away from the, they didn't really touch much on the IBMC stuff. It's just, you know. Furthermore, in reviewing a preliminary injunction motion, a district court may rely on blah, blah, blah. The exhibit is consistent with IBMC's declaration and includes
What's the blah, blah, blah?
Data and contextual cues sufficient to support its probative value. The text message in November 3rd, 2023 directly corroborates paragraph 7 of the declaration. The defendant transmitted a sexually explicit video of plaintiff to her. How does that... the date corroborates that I sent them a video? In what world does every... Okay. Defendant's claim that this message lacks probative value is contradicted by his own recognition that it supports plaintiff's...
If it shows you had intention to send the video, and then the video was sent, it's supporting evidence. It's not evidence in and of itself, but it is supporting evidence.
Jurisdictional arguments under the Carty statute. Defendant has failed to provide to present any valid reason for the court to disregard.
In the same way, we have supporting evidence that the snarkers and people from Hassan's camp got CPS called on Ethan, even though we don't know. I know that they'll harp on this forever. We don't know the individual person who called, and they go, see, so you don't know who called. No, we know what group gave that information that led to them making that call. We know why. We know that their motive behind the call came from denims, platforming bad empanada. That's where the motive for the call came from. And motive matters. Is the motive in and of itself evidence? No, but it does support the claim. You know, kind of like in a murder trial. It's the difference between first-degree murder and second-degree murder is motive. Motive and planning.
Restricted declaration or the corroborating evidence of IBMC's declaration and the corroborating text message are properly before the court for purposes of the preliminary injunction determination. IBMC's non-testimony at hearing does not warrant exclusion. Once again, defendant is litigating in bad faith by deliberately distorting facts. Defendant asserts that Abby failed to appear to testify at the hearing and that IBMC refused to appear or testify at the preliminary injunction hearing. But defendant knows that neither he nor plaintiff requested IBMC to testify, and there's no evidence to support his spurious assertion that IBMC refused or failed to appear. Defendant also deliberately attempts to mislead the court by stating plaintiff's counsel refused to accept service of a subpoena on her behalf. IBMC has thus far avoided personal service. Defendant did not provide any evidence in support of these spurious assertions, or can he? This is because the reference request was on May 15th, 2025 for a subpoena to produce documents, not for IBMC to testify at the hearing. Moreover, plaintiff's counsel never refused to accept service. Instead, less than 24 hours later and before counsel could respond, defendant's counsel said he would proceed to serve IBMC himself. What, and then they didn't respond to it? Defendant has not provided any evidence of attempts to serve IBMC, and there's certainly no evidence she's avoiding service. How do you have evidence that somebody's avoiding service? How do you even do that? I can't like publish emails or whatever, but...
You could have evidence that someone's supporting service if you sent someone to serve the papers and they ran from them or hid from them or, you know, tried not to do everything they could to avoid taking those papers as they were served. Of course you can have evidence that someone is avoiding service.
Records of dates and times you attempted to serve. Oh, maybe if they use a service provider. I wish they might have. Maybe that'll show up in another filing, I guess. Plaintiff has no obligation to call every declarant as a witness for the hearing, and the record is clear.
There you go. He got there. Took him a minute, but he got there. All right, go back to this.
It did not seek to call Abby Pxie either. Defendant chose not to subpoena or depose Abby Pxie in advance, despite having notice of her identity and the substance of her declaration a full month prior to the hearing. The court's order scheduling the hearing did not state that all witnesses needed to testify in person or that the declarations and other evidence submitted would not be considered. That is true. She didn't need to be there. That is true. But you would imagine that...
For instance, Casey Tron tried to avoid service. And she openly admits to that, where she was like, they had to go through her dad to get to her because she wouldn't take being served. They tried to serve her and she wouldn't accept the papers, blah, blah, blah. So they tricked her dad into serving the papers to her dad by using his disability or blah, 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 whatever she claimed. She claimed they used his disability as a way to get to him so that they could serve the papers to him. They probably tried to serve it to her first and she, wouldn't take it. So, God, the Cybertruck's ugly, even in Fortnite. And she wouldn't take the being served, so they had to, go through her dad. They wouldn't have had to go through him if, I would imagine, they wouldn't go straight to her dad to serve the papers. They would have tried to go to her first. I believe they legally have to try to serve her first. And if she's avoiding service, then they're going to do what they got to do to get her served so that she has to come to court. So that she's, so that she's subpoenaed and legally required to show up that they can say, we served her.
You would want your solo witness that is holding your subject matter jurisdiction to be there. You would imagine that, but who knows? Who cares? Courts do not require personal testimony from every declarant, where the written declarations, supporting evidence have been timely submitted. Technically, I don't even know if either of us needed to be there. I think technically we both could have skipped it, but I don't know if anybody's required to be at that hearing. I'm not sure. I'm not 100% on that. Affidavits?
Typically, no, but it's in your best interest to be there. Only your lawyers have to be there for it, though. That is true.
They're ordinarily inadmissible at trial. They are fully admissible in preliminary injunction proceedings. Defendant's argument that he was denied the opportunity to cross-examine Abby Pxie is baseless. Defendant had over a month's notice of Abby Pxie's declaration and its contents, but failed to issue a subpoena, notice a deposition, or otherwise secure her attendance at the hearing. The corroborating evidence of the text message presented nothing, not already in the declaration, and thus does not change the fact that defendant had a month's notice. Plaintiff was under no obligation to call every declarant, and defendant's strategic choice not to compel Abby Pxie's testimony constitutes a waiver of any objection to the court's consideration of her declaration or the corroborating text message. Defendant did not object contemporaneously, nor did he move to strike the declaration. His silence and inaction constitutes waiver. A party cannot remain passive and then claim unfairness when the record closes. As a final matter, plaintiff notes that the defendant had not objected to that portion of the motion requesting that the unredacted version of the exhibit be filed under seal. The exhibit plaintiff seeks to submit is not new evidence, but it's merely corroborative declaration. Okay. Jesus Christ. You kind of skip the last part. What does that mean? What does what mean? What last part? The last part was just a conclusion or summary of why is all this so slow to have anything happen? It's court. It takes a while. It's just a summary of everything that was said. Did you reach to subpoena her? Yeah, we've been trying to. But
1 minute it takes a while, but then you point out constantly how, this started in February. Why are we just now hearing about it? Yeah, you acknowledge it takes a while. So you do understand how this stuff works. Cool.
But initially they said that they were representing her to sue me, and then nothing came of that. And I think we requested to do something through her lawyer, but then they said that they don't represent her, so they can't accept her. I don't know if they said specifically they don't represent her. They said that they can't accept service on her behalf. And then apparently we've been trying to serve her, but we can't find anywhere to serve her for documents. So Destiny, chances of it getting unsealed. It should.
Yeah, I think the reason they were able to serve Casey Tron's dad as a way to serve her during her lawsuit was the fact that she, I believe, still lives with her parents. So, obviously you can serve a parental figure if you live with them. Yeah, like serving a parent counts.
Be unsealed. It should be. We just have to wait for the judge to rule on it. My understanding is there's like no basis and no world where that actually happens, where the judge would allow a public hearing to retroactively be sealed like that. We have to fight for every hearing to be public. I don't know. Who knows? If it's sealed, then you can even talk about it from your memory. Yeah, I'm pretty sure I can talk about it from my memory of what happened. But I wanted to. It would just be nice to read the actual transcript. Do you have to wait until December for summary judgment? I think you can file summary judgment anytime.
Having the actual transcript would be like his argument there, to be like, well, now you can't say I'm lying because I can actually prove the things I'm remembering are factual and not just me remembering things. Cool, thanks for the win, dumbass.
You want the discovery phase, but it's best to wait for most of the stuff to be in. So, okay. What are the chances that anyone who talked on the situation takes on their video or at least addresses the new changes later on down the line? Probably super unlikely. Who knows? I don't even know how to. Because I think because some people are trying. The narrative is shifted over and over again based on how plaintiff looks. And now that they look super, like every 10 IQ point drops, there's like a new narrative. And right now the narrative is just that if I win, it's on a technicality. Or some people are, even a lot of you guys are doing, they're like, oh well, they both did something really wrong. And it's like, no, or we just had an understanding that plaintiff is misrepresenting because she's basically paying that she got outed as streamers. But who knows? We'll see. I think this is our final brief before we wait for the judge to rule on a bunch of things. How long do you think it'll take to rule on stuff?
All right, home stretch. I'm going to wait till he's done reading it. I don't care about all his thoughts at the end. I just wanted to get the information.
Hopefully within a couple weeks. I think is the expectation. Plaintiff Jane Doe's reply in support of motion to have June 3rd, 2025 evidentiary hearing transcript filed under seal. Comes now. Plaintiff Jane Doe, blind through undersigned counsel, hereby submits her reply in support of her motion to have June 3rd, 2025 evidentiary hearing transcript filed under seal, and respectfully states as follows. Introduction. Defendant's opposition, ECF 101, distorts both the record and the applicable legal standards and reveals that his only interest in opposing sealing is financial and performative, not rooted in any public right. Like, I don't have the public right to have
still
a
got
public
more
viewing of my
colors for that
court
than
staff.
the last
Good
two
one.
sets of
But
tires.
plaintiff does not seek to shield herself from embarrassment or scrutiny, as defendant suggests. Interesting. Rather, she seeks to protect deeply private, sexually explicit, and mental health-related testimony from being broadcast to over 1 million online followers by a political streamer who has a documented pattern of weaponizing public proceedings for harassment, monetization, and spectacle. That's crazy, given that she's the one that filed a public case and also, prior to this, made a public Substack that was full of a whole bunch of, well, just lies. I was going to say speculation, but not even. Just she knows they're fucking lies. But okay. Defendant has, throughout the case, used his platform to publicly attack plaintiff, her counsel, and even third-party witnesses. Just keep repeating the same. I wonder if it's going to be in like every single filing that Jessica and Queeman are third-party witness. I wonder if they're just going to repeat this over and 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 over again. See ECF number 73. Blah, 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 blah. If the transcript is unsealed, I don't think it's technically sealed. I think it's like it is sealed, but it's while the judge is going to make a ruling. So we're not really asking, I don't think, for it to be unsealed, but to deny their motion to seal. If the transcript is unsealed, it is all but certain that it will be publicly read, mocked, and monetized online in ways that will inflict real and irreparable harm. I'm sorry, if your under oath testimony is mocked, I mean, that's on you. I mean, what do you mean? This is again, it's like they want to have like a private Discord call, but they want to pretend it's court, or they want to go to court and pretend that they can treat it like a private Discord one-on-one call. If you want to sue somebody publicly and you want to do public filings and all these things, then that's fine. We can do that, but you can't have this stupid double standard. Indeed, defendant has already explained.
I mean, he's right there. If you're coming out publicly with it, you're coming out publicly with it. Like, there's no denying that. So she can't have it both ways. She can't come out publicly and then say, I don't want it to be public. I mean, even if you're making the argument that he's making it more public, it's too late. Like, you should have filed for it to be sealed beforehand. He is right on that.
Explicitly stated that he will read the transcript out loud on his platform if it is unsealed. Yes. I will indeed go over my publicly available, publicly accessible filings for the court case that plaintiff initiated. Is that a problem? How unconfident are you in your own under oath testimony that this is such a threat to you? At minute 12:09, this hour-and-a-half video is solely about the June 3rd hearing. It was filmed on June 3rd and posted on June 4th, 2025, and to date has 353,981 views. Magistrate Judge Torres, who presided over the June 3rd hearing and heard the testimony.
So I give it to him on this point. This point's pretty stupid of them to point out the fact that he's reading the public documents to people, and that because a bunch of people are watching it, it shouldn't be allowed. No, either they're public and available or they're sealed. I mean, you can make an argument that his commentary and stuff during it is misrepresenting it. Fair. But the actual act of reading it itself, no.
Testimony readily granted plaintiff's motion to seal the transcript. I'm not aware of that. I believe that the transcript was sealed while they were awaiting a hearing on the motion. I don't think this motion was ever granted, but I guess we can go read the exact language. ECF 91. Paperless order granting in part 88 motion to seal. We direct the clerk to maintain the transcript at DE 90 as fully sealed pending further order of the court. So this is just, it's sealed while the magistrate judge is making a ruling on it. But we can also just lie, I guess. This is fun. They just lie. Defendant has provided no legitimate reason to unseal the transcript, nor is there any. Okay. Plaintiff's privacy interests outweigh the public interest, thus there is good cause for sealing the transcript. The common law right of access may be overcome by a showing of good cause, which requires balancing the asserted right of access against the other party's interest in keeping the information confidential. In this case, they vacated the lower court's order unsealing documents because it erred by applying the heightened standard of compelling interest rather than merely good cause or document sealed. The content of this transcript, combined with the defendant's highly unusual use of his public platform, meets the standard easily. Now, keep in mind, plaintiff decided, who filed under a Jane Doe, to publicly inform the entire world about my revenge porn being leaked online, and then in multiple court filings has directed everybody to websites to find it. But thank you. Okay, yes. My highly unusual use of my public platform. Thank you.
And he's got a good argument there for bringing it up, is that she was the one who brought attention to it first. She could have filed it without bringing attention to it. Like that she could have done. She could have filed it and just not made a Substack about it. And that's going to be the argument there. And I don't see how she can argue against that one. That one's going to play woefully against her as not wanting this to go public. If she's the one who, announced it publicly first.
Courts are especially protective of sexual privacy and mental health testimony, two topics directly implicated in the transcript. The defendant conflates the applicable standard and relies on inopposite precedent. The opposition asserts that heightened scrutiny and compelling government interest are necessary, relying on Globe newspaper v. Super. That was a criminal case, and the standard is not applicable to a civil case, and also erroneously contends that the records should not be sealed absent extraordinary circumstances. Opponent relies on Doe v. GA's Department of Corrections for this contention, but Doe says no such thing. Moreover, Doe is distinguishable because it is a case pertaining to conditions of prisoner confinement, and it is undeniable that the public has a powerful interest in the non-identifying information involved in these proceedings. There's no I remember the underlying cases up here. I've only read one of these underlying cases. Also,
yeah, and his lawyer's argument there that the public has a vested interest in it because it is a public figure can be also proved by all of the views that they're showing that his stuff is getting, that clearly the public has an interest in it.
So yeah, for sexual privacy, like Pxie already made a public post on everything, and it's posted to this day, like on every. So I don't know what, but okay. Here, plaintiff's claims are based on her right to.
I wish we had footage of her being served. I mean, she wouldn't be served because she's the one doing the lawsuit. It's oh, you mean Casey Tron? Yeah, I wish we did have footage on Casey Tron being served. That would be hilarious. But clearly, I think it's pretty clear that she tried to avoid getting served, and that's why they had to go through her dad. That's my bet on this here. Oh boy. Might stop this for a second. I just got a comment on our YouTube video about Pirate Software. Normally I don't respond to comments, but we'll just read this one live out loud. So if you're watching, bud, after you made your little comment, if you notice I was live and you click the button, DMHZMKN, Jesus Christ, with these crazy fucking names. This is clearly a troll account. But this is such a stupid movement. If you buy a car, you expect one day it will cost too much to keep it running. You know things don't last forever. You wouldn't legally enslave a car manufacturer to infinitely keep your car running. That's not what the movement said. I even clarified that in the video. You clearly didn't fucking watch when you made this comment. No one is advocating that the government force devs into fucking slave labor so that they have to work indefinitely on every game possible. Also, that means that every time you make a new game, you have to hire a bunch of new devs because they're going to have to work forever on that one game. Oh, we want to make another new game. No, we don't have an infinite population for an infinite number of people to infinitely work on games. That is retarded that you think that's what this movement is about. It's clearly not. All it says is that it needs to remain in a functional, playable state. That's all it says. There are a number of ways you can do that without the devs being involved. You don't have to force the devs into slave labor. The obvious, easy answer to it is that, hey, can you design your games so that in the future, when you shut them down, server functionality can be transferred from the devs to the community so that they can keep it running or people can host their own servers should they wish to continue playing. That's fucking it, man. It's that goddamn simple. I don't understand. This is clearly a Pirate Software fan who's only gotten Pirate Software side of it and clearly didn't even watch the video where this guy is debunking all of the shit he's saying in this message. So you wouldn't legally force a company to provide you with service for all time or to open source their IP. No, you don't have to force a company to endlessly service your car. But you have the right to keep that car as a consumer in a functional working state forever if you want. You can do that yourself. Yes, you have the right to take your car to any mechanic you want and keep it running indefinitely. My dad still has my grandpa's truck from the 1920s and he has kept it running. He is a mechanic. He had the right to do that. I would argue that keeping a truck running for 100 goddamn years shouldn't be on the manufacturer. But if the customer wants to do that, he can. The problem, and what this movement is pointing out, is that that right has been taken away from the customers. We don't have the ability to keep the game running once they shut it down. You have the ability to keep your car running once the manufacturer says they will no longer service it. That's the difference. We want the same rights car owners have. You haven't proven the problem wrong, you've highlighted it. So thank you. Guess I'll have to clip this to put this as a link under your comment so you can see how just ridiculous, so there's the last two words in the comment, how just ridiculous your comment is. Hey, quick question, quick question, commenter, because I am going to cut this for you to see in a clip. Now that I've read your comment, you've got your little 2 minutes of minor internet fame because nobody watches me. But I am addressing you directly. Just a quick question based on your message before I go. Does Pirate Software's dick taste like Blizzard? Like, is it cold? Like, does it taste like a Dairy Queen Blizzard? What flavor is it? I want to know. And do you not have a gag reflex, or do you actively choke on it when you write these comments? Fuckwit. All right, back to Destiny.
To privacy, and as the defendant is well aware, the transcript at issue includes testimony about plaintiff's private mental health history. No, just about stuff concerning this, which she's already made public. Details that could lead to her identity. No, that's not true. Intimate sexual communications shared in confidence. This stuff is already all publicly available online. And testimony about sexually explicit content unrelated to the statutory liability issues. I don't even know what that is in reference to, but okay.
Are they trying to say he shared stuff other than what is originally shared here? That he shared sexually explicit stuff other than this? Hold on, go back. Read that again. Read that part again.
Identity. No, that's not true. Intimate sexual communications shared in confidence. This stuff is already all publicly available online. And testimony about sexually explicit content.
All right, this last line.
Unrelated to the statutory liability issues. I don't even know what that is in reference to, but okay.
Oh, sexually explicit conversations. So you talking about, I think they're referencing you talking about how good or bad she is at sucking your cock. Because you did give her a rating based on the video. Like, you didn't just share the video, you gave it a review when you shared it and said she wasn't very good. So, and I think you've said that to other people, not just the person you shared it to. So I think that might be what they're referencing there. Hey, what's up, Bowen? Welcome aboard, man. And thank you for the donut, by the way. Generous, very generous.
Subject matter of the transcript is traditionally considered private, not public. Yeah, if this was true, then why didn't they? They should have moved for this to be a private hearing instead of a public one. But
true. Them trying to change it after the fact does make them look pretty bad. Long time no see. Yeah, I took a break from streaming for a little bit, but I'm back now, baby. Also, I still kept posting stuff on YouTube and whatnot, so you can always follow me on YouTube and watch those videos. Be sure to like and subscribe. I'm trying to get monetized for those videos. So that would be greatly appreciated.
in determining the weight to be accorded an assertion of a right to privacy, courts should first consider the degree to which the subject matter is traditionally considered private rather than public. Financial records of a wholly owned business, family affairs, illnesses, embarrassing conduct with no public ramifications, and similar matters will weigh more heavily against access than conduct affecting a substantial portion of the public. I haven't read this underlying case, but I'm almost certain that this probably pertains to like discovery and stuff that's not like central to the actual court case. But I'm just lazy to go through this, so. And every other, it's like, everything they cite cases are just horrible. But further, foremost among the competing concerns that a court weighing disclosure must consider is the privacy interest of the person resisting disclosure. Courts consistently recognize that sexual and mental health information is considered private and not public. Justifying sealing, especially when public disclosure would serve no legitimate function, but instead expose the party to stigma and harassment, would serve no legitimate function. Excuse me. Stuff that happens in court is presumed to have public access, and there's a huge right of presumption of public access.
It depends on the court and depends on the stuff. Some stuff isn't public access, just like federal court won't have videos, which is why we don't have videos on the Diddy trial, which, by the way, they have reached a verdict in 4 out of 5 of the charges. They're just waiting on the verdict on the 5th charge for Diddy, so we'll be getting a verdict on Diddy here pretty soon. I also made a banger tweet about them coming so close to a verdict on my Twitter. You guys should check out. It's tweet's a banger. I stand by it.
I don't have to say that there's legitimate function. That's assumed on my part. You are the one that has to overcome a significant burden there to prove that it should be closed. But and they can say your presumption in favor of public access.
Sure.
Here, the testimony in the transcript does not concern public officials, nor does it affect public concerns. Thus, there is limited public interest in allowing public access to the transcript. It concerns my court case. What? Whereas plaintiff's interest in sealing the transcript and protecting her private sexual and mental health information is high. You already made a public case.
Yeah, all right, I'll give it to him here. The lawyer's kind of contradicting himself when before, as part of his argument, he's saying that the public has a vested interest and this is why we should know things that Destiny said. But also, the public's vested interest doesn't outweigh her desire to remain her privacy. So, like, it can't be both. Like, I'll give it that. The lawyer is kind of contradicting himself a little bit there.
We talk about all this shit. Like, what the nature and degree of the injury weighs in favor of sealing. Nature and degree of injury must also be weighed. This will entail consideration not only of the sensitivity of the information and the subject, but also of how the person seeking access intends to use the information. Commercial competitors seeking an advantage over rivals need not be indulged in the name of monitoring the courts, and personal vendettas, similarly, need not be aided. This is not a personal vendetta, though. This has to do with a public civil court case. It's not just a personal vendetta. But it's so stupid. Defendant purports to be opposing the sealing of the transcript out of concern for the common law right of public access, but it is transparently obvious that he wants the transcript to be public only to serve his own personal interest. Part of the public right of access is for the personal interest of the people involved in the court case. Yeah, when I talk about like habeas corpus, well, it seems like they really think that people should be read charges when they're arrested and not just secretly arrested. But it seems like he only wants it so that it doesn't happen to him. Yeah, duh. Yeah, of course. It is beyond any doubt that if the transcript is unsealed, the defendant will publish it on his live streams and also read it out loud for the merriment of his hundreds of thousands of followers. Yes, it's a court case. Public, you want it.
Yeah, and if it's public, he has the right to do that. So saying that we want something to be made private because he's going to exercise a right that he has if we don't is really stupid. Like, I'll give him that.
To file a public case against me.
Sorry, forgot to ask. Oh, yeah, you can. Don't worry about it. I'll admit it's a little weird after I had kids, but, like, I get it. It's not a big deal. Like, it's so... I know what you mean by it, and it's such a common phrase that everyone is socially accepted now that I get that it's probably not as... Yeah, like, it's not as weird as... Feels a little weird at first, but I don't care. I don't really care. My wife gets more weirded out by it than I do. I'll put it that way.
All of this is a public court case.
Can you guess when I started watching? You just curious if you can recall. I imagine it had something to do with the Ethan or Hassan bit, right?
All of this is public. The access to all of it is public. And there has been ample evidence presented to the court of his hours-long discussions of the details of this case on his online platforms, including threats, harassments, and ridicule of plaintiff, witnesses, and counsel. I have not threatened or harassed plaintiff. I have the right to ridicule everybody involved, of course. What do you mean? I'm not allowed to say anything while these people are ridiculing me? That's such a stupid contention. The Nixon court.
True. Like, he has a right to free speech. You can't use his right to free speech against him and say, well, we should take this away from him because if we don't, he's going to use his right to free speech to talk about it. Either it's public and he can't talk about it or it's not. He's absolutely right on this. If they wanted it to remain private and if privacy was a concern, that's the way they should have filed it. They filed it publicly. They didn't seal it. So it wasn't a concern before. They're going to have to like substantiate why it's a concern now. And I haven't seen that yet here. I'll give him that. Close. First video was you reacting to the content
Or express particular
So still in that circle of people.
concern about protecting from purely prurient interests the display or disclosure of otherwise embarrassing private or familial information obtained through the courts. Purely prurient interest. Again, this is just whatever. It explained that the common law right of inspection, though undoubtedly powerful and never lightly subordinated, must give way where records are sought merely to gratify private spite or promote public scandal for the publication of the painful and sometimes disgusting details of cases. This isn't a private spite. This is a public court case. The Merlis court, I did read this underlying case, reversed the lower court's decision to unseal a judicial document precisely because the lower court failed to consider the motives of the party seeking to have the document unsealed. Courts should consider personal motives, including an applicant's desire to pursue an individual vendetta at the third balancing step of the inquiry in connection with any asserted privacy interests. This case, again, I don't bother reading all these pages because they're so stupid. This case is insane because what the court rejected here, so Eliyahu, Jesus, Merlis, this person sued Daniel Greer, who was a rabbi, for sexually molesting him. There was other testimony that was brought in. So it was a non-party witness. So they weren't part of this original case. They were a non-party witness in a 2016 civil lawsuit in the District of Columbia. In that suit, the plaintiff, Merlis, a former student at a religious school in New Haven, Connecticut, accused the defendant, Daniel Greer, the former religious leader of that school, of sexually abusing Merlis when Merlis was a minor and a student there. Merlis sought damages from Greer for that abuse in connection with those proceedings. So Merlis here was suing Greer, okay? In connection with those proceedings, another person, not a party to the case, another person, gave a video-recorded deposition lasting several hours in which he testified in detail to having also been a victim of Greer's sexual abuse several decades earlier when was a minor and a student at the school. Further testified in his deposition that he'd known Greer's abuse of Merlis, which occurred when was an adult and employed at the school. A transcript of the deposition is publicly available, but public access to the video recording itself is the subject of this appeal. So the transcript exists. This guy, this Dressler guy, wasn't even a part of the court case, and I don't know why, but he was trying to make it so that deposition would be released publicly, the video of it. After trial, Lawrence Dressler, the interested party appellee, in the appeal now before us, sought the DC's leave to access the video recording of Hack's entire deposition. Using the screen name Larry Noodles, Dressler had written voluminously on his blog about the trial and disparagingly about both Hack and Greer. He informed the court that he sought to copy the video so that he could post it publicly to his internet blog. So this guy isn't even a fucking party to the case, and he's trying to get a video of a witness in this case, who's also not a party to this, but a witness to this case, where the transcript already exists. And then the court said, no, you don't need access to that video. We're not going to give you that video. And they're trying to compare that request to my request. The Merlis court reversed the lower court's decision to unseal the judicial document precisely because the lower court failed to consider the motives of the party seeking to have the document unsealed. The person seeking that transcript, that deposition, the video deposition, wasn't even a party to the fucking case. And the witness here wasn't a party to the case either. Like, it was also in a different district as well. Yeah, this is a second district case, not a ninth district case. But it's just like such an this information is relevant particularly when an individual, and not the press, seeks public access to sensitive information. It wasn't a party to the case. Here, defendant is not a typical litigant. He is a professional online streamer whose income is largely derived from publicly discussing controversial topics, including this lawsuit. Scumbag, subhuman degeneration, acting like I've made more money covering this than I wouldn't have otherwise. But since the outset of this case, defendant has repeatedly posted about it on his streaming platforms, mocked plaintiff and her legal team, and weaponized court filings for online content. Weaponized court filings? Oh, I'm sorry, I'm in the 11th Circuit, not the 9th, my bad. 9th Circuit is California and Washington, Oregon. How I'm weaponizing my court filings by reading them? Defendant has also publicly ridiculed plaintiff's mental health, sexual history.
It depends. I think they're, I think this is poorly worded. I think they're referencing the commentary he's giving during his readings, that he's using basically the court documents as fuel for his arguments that he's making during the readings. I don't think they would say you were weaponizing it or you were using it if you were just reading the documents in the way that I read, like the Frogan or Denham's ones on stream, where I just straight up read the documents and saved my commentary for the end, so I didn't, try to poison the documents during the reading with my commentary. I'm pretty sure that's what they're referencing there, or that's what he means by it. But it is poorly worded.
Witnesses who supported her case. I'm allowed to have an opinion about these things. No one is targeting anybody. No one's threatening anybody, except they keep trying to throw Driscoll and Queen who aren't a part of this case at all. But This is not speculative. His pattern of commentary is well documented and includes live streams, tweets, and reposts designed to stir.
I'm going to look up Justicle's channel here after this to see if he actually joined the case. I could have sworn I saw a video by Justicle, and I don't watch Justicle's content, but I remember seeing the title and it showing up in my feed of the I'm joining the Destiny case. And if he has joined as a witness and he wasn't a witness before, then Destiny may not even be aware of that.
Or harassment by his audience. This is also like kind of a little bit like in support of their gag order. So like I just am not allowed to talk about this at all. Obviously, I'm going to say you're lying. I believe you're lying.
Which I think he's aware of it and just playing dumb, because I don't see why he wouldn't be aware of that.
And it's, I mean, we have a disagreement of fact here. That's why there's a court case at all. It's like what? Also, keep in mind, all of this is buoyed so heavily by the fact that she made a public Substack post with an unhinged list of calculations. Or, I'm sorry, I just read a thing in chat here. With an unhinged list of accusations against me before even filing the court case. Like, how could you possibly gag me against all of that? Indeed, defendant's only plausible reason for opposing sealing is his interest in continuing to exploit the transcript for personal profit and performative harassment. For this reason, the transcript must remain sealed to prevent further and additional harm to plaintiff. Imagine being so harmed by your own words. Under oath, by the way. Defendant contends, without any legal authority, that plaintiff waived her right to have the transcript sealed because 1, there were members of the public present, and 2, plaintiff did not request sealing until the day after the hearing. First, defendant grossly overstates the public nature of the hearing. Defendant falsely, we've got bull and asserts that multiple individuals unaffiliated with the parties were present in the courtroom gallery, some of whom took contemporaneous notes and later published detailed summaries online. I don't remember if there was, I thought there was more than just one person. My fan in the back, he might have been the only one. I thought there was another person. I don't remember though, because I'm not looking at mine all the time. Opposition, P7, page 7, and again, members of the public attended the hearing, took notes, and later discussed the proceeding online.
And I'm not sure if that's going to play to their favor or against him, the fact that one of Destiny's fans was in the court. So, you know, that could play to his argument that it's public and it's been public the whole time and the public has vested interest in it because the public actually showed up in person to watch it. Or it could play to her benefit about how obviously like people who are against her and want to use this information against her are going to any means necessary or showing up to get it. I don't know. Like it's real hard to say on that one. I miss that shortcut every time.
And in various public forums, discussed the proceedings online and in various public forums. Oh yeah, multiple, some might have been staff or not. I'm not sure, I don't know. But in fact, only one individual sat in the gallery, an associate of defendant with the screen name Zip. An associate? That's just a fucking lie that's being proffered with no evidence and no proof.
The fact that it could be a misinterpretation, but the fact that you kept talking to him directly in your retelling of the hearing and he was in your chat and you were like, Zip, you were there. I could see how people could think he was another content creator or an associate. I'll be honest. I thought he was at first too. I thought he was a friend of yours or something at first. It wasn't until after 40 minutes in, I was watching that when you stated that he was just a chatter. You were like, a chatter was there. And I was like, oh, so this wasn't a friend of yours. You were sounded pretty friendly and chummy with him. So I could see how someone could interpret it that way.
Proof whatsoever, but okay. And his name isn't even Zip, but no press were present. The proceeding was only discussed.
You called him Zip during the video. It's clear that they watched that video of you.
Online by the defendant and Zip on defendant's streaming platform. The video stream makes it clear that Zip was the one taking the notes at the hearing, so that defendant could rely on them for his live stream. Ooh, okay, I've never I didn't even know the guy at the hearing. I didn't even know he was one of my fans.
But the way you talked to him and about him in the video that they're referencing, that's not clear. That's what's being said here. You weren't very clear on that fact. It sounded like you knew him. And I'll contest to that. I watched that video because I think we reacted to it on stream because I wanted to know about the case. And it did sound like you and this guy were friends. Oh, pulling out at the end. Boom, with the win. He's so pissed.
Zip, have we ever communicated before? I think the very first time we've ever communicated was when I was leaving the courthouse and he said that my...
Yeah, you're in chat with him now and you're like, hey, Zip. You just keep talking to him like you know him. Like he's a member of your Discord, like he's a friend. The same way you talk to other streamers and people you have called friends in the past. There's absolutely no difference in the way you were addressing Zip during that stream than the way you addressed Pxie or other people you've called friends in the past.
Coat was messed up in the back. This is the first time we've ever communicated in our lives. Are they even trying at this point? What they're doing is they copy paste stuff. I wish I was joking. And nobody will speak out about this because everybody in all of my surrounding X communities are spineless and cowards who infinitely not condescend to, but treat white crying women like actual children. All they do is just copy paste stuff from Kiwi Farms and then just put it in a court doc. That's literally all this case is. Hoping to survive summary judgment and then hoping to further malign or embarrass me or reputation tank me or whatever. That's the only, and then waste my money. That's all this case has become. The video stream makes it clear that Zip was one of the article referenced in the opposition as support for defendant's false statements was based solely on defendant's video stream and included a link to...
It's a fucking confident as fuck statement right there. That they're just doing it, that they're, A, copy and pasting directly from Kiwi Farms. I mean, I don't doubt that they're sourcing Kiwi Farms for information, but I don't think that's all the information they provided. And 2, I don't think that they're doing it to try to bleed you of... I mean, you can argue they're doing it to try to bleed you of your money, but the judge isn't going to fucking care about that. The court case takes what the court case takes. If they think they've got stuff to present to the court, they're free to do so. Your lawyers are free to do the same. So I would argue that, like, you have to remember, it's not just bleeding you of your money, it's bleeding her of her money too, because she has to pay for court too. You have a lot more money than she would. It's in your best interest to drag this out as long as possible and bleed her of her money than it is in her interest to try to bleed you of yours. She'll run out of money before you do. So that part doesn't make a whole lot of sense to me. Unless you're claiming that this lawyer is a friend of the family and doing it pro bono or something. Like, did the lawyer say he was doing it pro bono?
To a portion of the stream. The author of the article has acknowledged that he was not in the courtroom and that the reporting is based explicitly on the video clip that is also attached in the article from himself. I like they don't even try to upload stuff on their own or do. They literally just link directly to a Kiwi Farms video. Like, it's just, they're literally just pulling this. Also, it was one of the people on my thread on Kiwi Farms that apparently emailed and wrote to the guy who linked the article. But I like that this is, I think, is this third court doc now where they just linked directly to a Kiwi Farms thread? But
again, doesn't matter where it does not matter where the information came from as long as it is correct and accurate.
it's actually gross what Pxie's lawyers are doing. No, it's gross what she is doing. Don't blame it. It's not just the lawyer. She's not a fucking child. This is her representation. She theoretically has to approve these things that are being posted online, and she says that she wants to go to law school and whatever she can do with her 75 LSAT. In fact, the article was later amended to reflect this fact, and the original language changed to read. Destiny recently shared what he learned, or that he learned through court proceedings, that defendants' deliberate attempts to mislead the court should be sanctioned. Okay. Second, plaintiff's failure to move contemporaneously for sealing does not waive her rights, particularly where the emotional distress from the hearing's content and the anticipated misuse became apparent only after the hearing concluded. I like how they accidentally revealed the whole giveaway everything here. They were not happy with how the hearing went. That's the reality of what happened. And this is them saying it explicitly. After they realized that everything that they were trying to float here was f***ing bullshit. And when they realized that, oh, we didn't actually tell Pxie she has no f***ing idea how to speak in court like an adult, and yapped and rambled and said so much retarded, a lot of which is incredibly damaging to her case, then they're like, oh, we got to seal this shit immediately. Because a lot of this kind of fucks your, at least the public that you've posted about this. But I like how they say this here. The emotional distress from the hearing's content and the anticipated misuse became apparent only after the hearing concluded. What does that even mean? You thought it was a good person, and then after the hearing, oh, he might misuse, it's so gross.
I mean, it's true there. They probably weren't happy with the way the hearing went. From the transcript you read of the hearing, it sounded like it didn't go well for them. But have they said anything factually inaccurate here? Like saying they got it from Kiwi Farms, that's a nothing burger. It doesn't matter where they got it. It matters whether or not it's accurate.
Hearing sealing is routinely granted in similar situations involving sensitive sexual or mental health testimony, particularly where the threat of misuse or online harassment is credible and imminent. I would disbar people, but I don't know anything about that. If similar situations, remember, and they're citing this case that had to deal with a minor being raped by an adult, giving a video deposition in a case where he wasn't even a party to the case, and wanting to have that video deposition sealed, while the transcript is still publicly available. So it's not even remotely similar. Unless they have a different definition for similar, or they just don't do English much, I guess. It's actually insane that they would even use this word here, but okay. Post-trial sealing of a judicial document, a video deposition that was played for several hours during a public trial where party opposing sealing motivated by ill will and intended to publish the video online. I don't even know if I would agree with the term party here. They weren't a party to the original case. They were like an appealee party. It was a new thing. I think it was just an independent guy coming into appeal who wasn't a part of, he wasn't part of this case at all. Did they use the term party? Interested party appellee. He became a party just in the appeal here, but he wasn't a party to the original case at all. Is my understanding. I think somebody said online that he's a true crime blogger or something. What's it called? Larry Noodles? Tell us why that distinction is meaningful for the slow ones like me. Because one, the person requesting this video deposition, it would be like one of you guys requesting a deposition in my court case about...
He's basically saying that the reason it was denied in the case that they're referencing and why it doesn't count is because the person who was requesting the information and got denied wasn't part of the case. He was like a YouTuber or something filing a Freedom of Information Act request for this information, and he got denied. And they're trying to use that as a reason why we should seal this because, people might try to get this information or, basically. And that's why they're using that as their example of, see, this is why, because this happens.
About somebody else giving a deposition about me in a video form where the text was already available. Imagine Samantha did a video deposition where claiming that I died here 20 years ago or something, and you were somebody who's not even part of the case and you want the full video deposition of her testimony, and then the court says, well, no, you weren't even a party to the case. You're literally writing about this with the goal of harassing and mocking her, and it's not like it's not testimony from somebody who's part of the case. This is a deposition she gave, and the transcript is still fully available online, which it was.
Damn.
So it's not even remotely it's not comparable, 7 different ways. Yet Dressler, this is the non-party who's requesting the video deposition, Dressler identified no affirmative public need that would be served by general release of the video deposition when the text transcript was already available. Indeed, no other individual entity and no media outlet joined in Dressler's request. Privacy interests, so the whole text transcript was already fully available. This is not even remotely close. It's just so stupid. I'm sorry. The Merlis court found that the lower court erred by discounting the privacy interests of the person seeking sealing. The lower court's reasons that 1, the person's testimony had already been made publicly available, and 2, the person failed to request that the deposition be sealed at the time he sat for it, were specifically rejected by the appellate court. This is just bullshit. Similarly here, the court should reject defendant's baseless arguments. Plaintiff's limited public statements, no matter my request. Plaintiff's reliance on plaintiff's limited public advocacy is a red herring. Discussing her case in broad general terms does not waive her right to protect explicit details about her sexuality or mental health from being dissected in a monetized online video. Further, plaintiff's modest online fundraising activity does not equate to publicizing her private testimony. The hypocrisy of defendant's argument is glaring. Defendant, by contrast, is a professional content creator earning revenue by sensationalizing the case. It is just so unfathomably disgusting. Like, sensationalizing the case. Just to be clear from where we came from for this was her public Substack before any of the before any case went live. On November 29th, I learned that the streamer Destiny had not, also my full name, Stephen Kenneth Ponce, had non-consensually shared the content of me online. All of this is written to maximize, like, oh, like just kind of, no, it was of us. And online makes it sound like I was the one who published it to Kiwi Farms. So this whole statement is misleading. My dignity, peace of mind, and hopes for the future were stripped away in a mere matter of...
But is it infactual? I mean, that is what happened. And sensationalizing, that's open to interpretation.
Seconds following the betrayal of someone I previously trusted. I am at least the third person he has done this to. Other people can sue me if they want, and then we'll go through all of that. But obviously, she's adding this in here. It's not even technically her story and how, but hey, you know, I guess I'm harassing and causing him to go into hiding. I hope to be the last. I will not be commenting on the experience of the other women he has hurt, as it is not my place or story to tell, despite the fact that she keeps adding them in court document after court document after court document, when at least one of them is publicly stated, I don't want to be involved in this. I don't know why I keep getting mentioned over and over again. But I will, however, share my story in the hopes of preventing this from occurring again. I have known Destiny for around 5 to 6 years, and I often find myself in heavy disagreements with him. Despite this, I do my best to see the best sides of all people, trying my hardest to spread positivity and create understanding where I can. It's corny, but I want to meet people where they are and focus on which ways we can build bridges together towards a better future for everyone. Some people call this a fault of mine. They claim I am naive and should be more careful. These people are right. When I was 19, over 5 years ago, I was extremely sexually inexperienced and sheltered. So she wasn't 19. We started chatting when she was 20. We met when she was 21. All of these dates are easily verifiable. She still has all the chat logs to this. She, I assume, knows when her birthday was. So why the fuck would she? Why would you just lie about your age? Why would you lie about this? Right? We can just look at the logs. I know when her birthday is, and I know when we started chatting. So this is a lie. But I guess we want to be 19 to be freshly 19 or a teenager. I was extremely sexually inexperienced and sheltered. She makes it sound like she's like an actual being virgin, whatever. Like, you're literally recording videos with your boyfriend or somebody. What is wrong with you? But like to say this and make it sound like you're some completely, being severely terrified of leading someone on or sexual assault. I thought I could trust Destiny. I had multiple long conversations with regarding consent and boundaries. Well, what does this even have to do with anything? You didn't get sexually assaulted or led on. Like, what? So you can imagine my surprise when I discovered he distributed graphic content of me without my consent. Again, distributed what, to multiple people, published it online? And what, just of you? Like, it is meaningfully different. Am I just sending videos solo of her around, or is it so?
To multiple people? Did he distribute it to more than just Rose? Because, I mean, him distributing it to Rose and her getting hacked, I mean, that's not him distributing anybody it was distributing it to, or that it got distributed to after the hack, that's not his fault. Like, I don't see how you can blame him for the fact that the message got hacked and then the hacker shared it. I don't know why we're not blaming the hacker more, or why he's being left the fuck out of this. Unless she didn't really get hacked and some new information came out I'm unaware of. Last I checked, she got hacked, right? That this was a leak. Seems kind of groomy in my opinion that he knows the exact date she turned 18. I mean, true, but the accusation here isn't grooming. So, I mean, that may be the picture they're trying to paint, but the accusation's not grooming. I mean, him saying he know the, not really. Him saying he know the exact date she turned 18 just means that, yeah, I know her birthday. That's basically, it's a weird way to say I know what her birthday is, but he knows her birthday. And his claim is he started talking to her after she was 18 and 19, when she was 20, 21. So, like, it not really considered grooming to make it, because they're trying to make it sound like he waited till she was 18 before he started talking to her and he knew the exact age, which he did, but I can know the exact day you turn 18 if I know your age and your birthday. I can just do the math. I can then know the exact day you turned 18. I know the exact day my wife turned 18, but we didn't meet until we were in our 20s. So, yeah, that really didn't mean anything on its face. It's a weird way for him to phrase that. Jesus. Just saying I know what her birthday is. Like I knew she was of age. Like, that's all you had to say. Like, I knew she was 20. I know what her birthday is. Why is she lying about this? That's what he should have said. Instead of going, I know the exact day she turned 18. It's just a weird way to phrase that.
That we've filmed together. Yes, you read that right. Stephen Kenneth on the second sent graphic content of me to a random 19-year-old e-girl Discord kitten whom he had never met before, and then she published it to the whole world. You, by your own thing, now you weren't 19 or 20.
Wait, did she publish it or did she get hacked? I thought the story was she got hacked, unless we're going she wasn't hacked now, and that she shared it. But still, you can't blame him for her sharing it. You can't say he shared it with multiple people if he only shared it with her and then she shared it. Like, that's like, we can't fault him for action others took. Yeah, that's what I meant. It's weird that he pointed out. Yeah, it's a really weird way to phrase it. He might be autistic.
But aren't you describing yourself? Like, listen how retarded you sound here. Like, I was 19 and he was sending me videos. Also, He sent videos to another person who was saying, this, by the way, comes up in the transcript in a very hilarious way, but I can't read it. But like what? And then she published it to the whole world. Rest assured, despite never having met her, he at least spoke to her plenty of times on the phone. Yeah, this was just the same relationship I had with you. Like, what is the point of course, this is what he says happened. I think it is just as likely that he used her as a proxy to widely distribute this material while claiming deniability.
So that's the claim. You're claiming that he sent it to her. So the claim being made here now, that I'm wondering if he's about to point out or not, but the claim that they just made, using her as a proxy, the claim being made here now is that you sent it to her. You basically pulled an Ethan. Ethan put his content nuke out knowing they would react to it without watching it first. So she's claiming he sent her that knowing she would share it. So he didn't tell her to share it, but he knew she would. But earlier in the statement, you said that he sent it to some random e-girl he just met. Like, it can't be both. He can't have just met her, but also know her well enough to know she would share this. Like, again, this is it contradicting itself.
I think that she published this because she secretly likes seeing all of it online and she likes the attention from her video. Like, what an unhinged statement to make. I do not understand why Destiny would knowingly and willingly put me in a position where I would receive nonstop sexual abuse and harassment. If we believe him, he was trying to impress a barely legal teenager using my body and my person. If we believe, I've never said this ever, but that's a cool read here. Like, nothing that we filmed was as impressive as this. Like, what a stupid statement. The betrayal, coupled with the hundreds of messages I've received, filled with sexual harassment and abuse, have left me feeling hopeless and devoid.
I mean, I would believe that he sent it to her to try to get into her pants and impress her. From what I understand, his wife corroborated that story and said, yeah, that's what he did to me when he met me. Like, I think that's how he impressed his wife before he got married to Melina. Like, I think she even admitted, yeah, he's done this in the past. Like, this is not new, but he got consent in the past. And she's admitted that she's consented to him sending videos of them to girls that he tried to sleep with because they had an open marriage. So, yeah, there's a lot of evidence to prove that that's the reason why he sent it. So to act like them acting like that's a ridiculous reason and the judge shouldn't believe it, I'm not sure why they would say that because that's already on record.
Of almost all happiness. Wow, you're discussing your mental health and everything in your Substack. Nice. The only thing that has kept me going is the hope that I can bring this man to justice and have him face legal consequences for his actions. For the past month, I've been speaking to lawyers about my situation and what to do, and I've decided this is the best course of action. Now, most of the lawyers that she spoke with told her that she had no case, but thank God she has a family friend, I guess, that can litigate against me, so thank goodness for that. I will be suing him for some federal code that Lauren looked up for me, civil action relating to disclosure of intimate images, and for publication of private text in Florida. I will be seeking emotional and punitive damages for his actions. I've been told that a court case like this could potentially cost over tens of thousands of dollars. I am terrified.
Yep.
I mean, this guy talks about potentially suing Hassan as if for fun, and Hassan actually has the...
Yes, a court case like that could cost tens of thousands of dollars. But why are you acting like he's doing something to you? You're the one who initiated the court case. So you had to be okay with the price before you did it. I'm not sure how that's something you can hold against him when you're the one, he's the defendant. You're the one suing him.
The resources to defend himself. I cannot imagine what he might try to do to me in the process. Well, how do you victimize yourself before doing anything when you're literally like sometimes I wonder if he does this as an intimidation tactic. I wonder if he is purposely trying to put fear into my heart when he casually talks about throwing money into a lawsuit with a multimillionaire who can fight back, as if it's an indirect flaunt/warning over his capability of outspending me in whatever legal case I throw at him. At the request of my friends, I have been encouraged to link my GiveSendGo regarding this case here in hopes that we can raise enough for me to legally succeed. Whoever the next Joe Rogan of the left is, it cannot be someone that crosses sexual boundaries, violates consent, and puts women's well-being and safety at risk. It cannot be someone who puts women in positions where they will be sexually abused and harassed. It concerns me that Destiny spent interviewing potential DNC chair candidates such as Marianne Williamson or Martin O'Malley, who have no idea of what he's done. As time passes and he tries to position himself to have interviews with increasingly powerful figures such as Zelensky, I can't help but be filled with fear that Destiny may continue to succeed, despite facing no repercussions for his actions. If the Democratic Party wishes to succeed in the future, it cannot be a party that accepts the sexual exploitation of women. It cannot be a party that allows men...
Why are we bringing politics into it? I don't think the judge cares about this part. I don't think this part matters as much as she's pretending it does.
Like Destiny to break into the mainstream for allowing him access to such spaces would be a direct endorsement of his behavior. I have been told that the payout might not be worth the harassment and attention I will receive. In an ideal world, I would do this privately, but I've been told that there's no realistic way the court will grant me anonymity. Like, did you not even read the statute that you cited? There's a reason why you proceeded under seal. Like, this is more just lies. Maybe she can't even read, who knows? This means my only maybe she dictated this, I don't know. This means my only option is public. I have been told by a variety of people not to go public. I have been told by some people that Stephen really does feel sorry, but I'm not inclined to believe them, especially...
Yes, you shouldn't have gone public. Like, the worst thing she could have done, especially if this is what she's trying to do with the case and make it private, the worst thing she could have done is announce the case publicly in a Substack. That is definitely going to be held against her.
Taking into consideration his actions regarding me. Regardless, what Destiny did is unacceptable, and I believe he will do this again unless he faces justice. Like, so brave of you to say all the... As soon as you have to actually sit your dumb ass down in front of a fucking judge and speak under oath, and your testimony changes dramatically, then now you want to seal the of that while leaving, like, dribble like this online to fundraise off of. Like, it's actually so annoying to me. I hate that. It's so annoying. By contrast...
Yeah, that Substack would definitely be held against her, especially now that you're given different reasons in the actual court filing than what you said in the Substack, and you made it so dramatic in the Substack, and like, all of your reasoning sounds different in this. Similar, but not exactly as dramatic. Like that subsect's definitely going to be used against her. Like there's no avoiding that.
Okay. He is mocked and doxxed. Doxed plaintiff supporters.
The lesson we're learning, again, through every YouTuber case we cover, is if you're going to sue someone, don't announce it, just do it. And if you're being sued, shut the fuck up. The minute you're served court papers, shut the fuck up. Shut the fuck up, shut the fuck up, shut the fuck up. If you have an active court case, shut the fuck up. If you plan on suing someone, don't announce it, just do it. Ethan didn't announce his until after the paperwork had been filed. And Denims, Frogan, Caseytron should at that point have all shut the fuck up. You keep talking about it, which means Ethan's going to keep talking about it. The more they talk, the bigger the hole they dig for themselves. The more he talks, it's not going to look great for him. I don't think he's digging as big a hole as they are. But she talked first, which is now going to hurt her motion for making it private because she went public first. She should have shut the fuck up. He's defending himself in a case. It's being brought against him and not accepting what I say clearly is showing guiltiness. Yeah, I mean, like you can't fault him for wanting to talk about his own case when you were the one who talked about it first. Like if she had just filed the lawsuit and not announced it, and the way the world learned about it was from Destiny, then sure. But she didn't do the cardinal. She didn't do the cardinal fucking thing that we mentioned here. The cardinal sin was not shutting the fuck up. That is exactly what she should have done.
Witnesses. Supporters now? What in the fuck is a supporter? Like a friend? Like what? Ensuring that public disclosure of the transcript would lead to further harassment and harm. Indeed. Right after the hearing concluded, defendant was streaming on his platform and mocking the plaintiff for having cried while she was testifying. Of course, yes. Yeah, because you're breaking down your own examination. This is unhinged. In his chat thread on his personal platform, defendant wrote to his followers that plaintiff had a big breakdown and started crying halfway through. We had to take a 10-minute break. LOOOOOOOOOOL. He also writes, I'm going to be honest, I got really uncomfortable when she was on the stand and started getting upset because it started to look like I hooked up with somebody. I thought I said retarded, but maybe mentally ill. This disparaging comment is followed by a laughing emoji. Defendant has provided no evidence of any similar publishing by plaintiff. Like, are you serious? Like, the person who literally accused me of using a person online as a proxy to post like 27 sexual videos of me online? Accordingly, plaintiff urges the court to maintain the transcript under seal. Alternatively, in the event the court determines plaintiff has not demonstrated good cause to have the entire transcript sealed, plaintiff requests that she be allowed to designate portions of the transcript as confidential and that the transcript only be unsealed in redacted form. I hope they don't grant this in part, because then it's going to be another 30 days to redact, and then we're going to probably have to do a brief or why we argue some stuff shouldn't be redacted, and then it's going to be like another 3 months. Like, Destiny, the LOL meme is actually misrepresented. You said that in regard to something else. Also, the messages are presented the wrong order. Oh, because they go bottom to top.
Right there.
Oh, true. I don't say she had a big breakdown. LOL. I was saying LOL because the hearing was an open court, but they want to steal the transcript from the hearing now. LOL. Locknox, she had a big breakdown and started crying halfway through. We had to take a 10-minute break. I think she was getting really frustrated. Oh, true. So they did, but they don't care. They don't care about lying in filings, and none of it matters because the plaintiff has no reputation or online anything anyway, and no one is ever going to say anything detrimental about her because it's a white woman here saying some unhinged rhetoric about this. So, the message of you realizing it was me at the hearing, meaning you didn't know me. Oh yeah, I like how they try to say that we were. Oh, Zip 45. Oh wait, Zip 45. Was that you this morning? Oh yeah, because I didn't even know who you were. Yeah, but whatever. Plaintiff respectfully requests the court rejection of his opposition, grant the motion to seal. Hearing expresses the public interest in having testimony involving sexual and mental health information, and identifying data be public is very low, and there is no identifying data in this transcript. And plaintiff's interest in keeping the information private is very high. You get to respond to this? Nope. This was their briefing. We already made our briefing, and hopefully within the next couple weeks, the judge starts ruling on a bunch of these motions. I just hope it's not granted in part because the redacting is just going to be another like 2 or 3 or 4 months to delay everything. How possible do you think it is that she knows her case is weak and her only goal now is to make you spend as much as possible? That is 100% what's going on. Obviously, that's what's going on. The Abby MC evidence is. I don't even want to say it's weak at best. They're knowingly lying about that evidence. They're knowingly lying in court. I think actually it might also be that Pxie might be lying to her representation, and maybe they don't know. So one.
There's someone who embodies the internet meme. I have the right to remain silent, but not the ability. True.
Thing I thought was interesting as I was recalling my thoughts about what was said in court. One of the things that they accused me of, and Pxie might just be lying to her representation, or she's for God who knows, is they claim that I never actually contacted a law firm in New York. They claim that that's a total lie and that I actually misrepresented that entirely, and I lied to Pxie the whole time about that. Now they might only be saying that because on Kiwi Farms they say that. They say that I'm lying about ever contacting a New York law firm. However, I can verify that not only did I contact that New York law firm, they know that I contacted a New York law firm because back when Brianna Wu was helping Pxie, I don't know if that's probably not, but Brianna Wu was trying to help Pxie behind the scenes. She contacted the same law firm that I had retained in New York, and they had to reject her because of conflict of interest. So she knows for a fact that I had retained a law firm relating to this case because she was rejected from that one in New York because it was the same one that I was going to use to pursue my case against Weep. So she knows it's a lie, even though they tried to float that in court against me a couple times. But it's, who the f cares, I guess. Literally like white woman power. It's unreal, dude. If I was a white woman, I would be the president of the world. Is plaintiff suing the person who posted the video? No, plaintiff doesn't give a f about the person who posted the video or the website hosting the video. The only thing she cares about is trying to make a name, taking me down because
yeah, it's very weird that they don't hold anyone accountable but him when like the fact that it went public came from someone else. He shared it with that person, but that person should be held accountable for sharing it, whether or not Rose actually shared it. Because I'm getting conflicting stories now. First, it's Rose shared it, and before it was Rose got hacked. So if it's a hacker, why aren't we going after the hackers? If it's a leak, why aren't we going after the leaker? He never shared it publicly. So them acting like he's responsible for her public image is the wrong route to go. They should be holding him responsible for violating her privacy. That he did do. But her public image, no.
She's insanely far left and is being powered by somebody who's insanely far right and has convinced herself this is her last like mission on Earth is to take out the evil or whatever. And so this is her life mission until this all ends. Was this illegal to give her said about Brianna Wilhelmina? I don't know. I don't remember if I said it or not, but she was helping her initially, which was stupid of Pxie and irresponsible on Brianna Wu's part because there is no attorney-client privilege between Brianna and Pxie since she wasn't retained as legal representation. So theoretically, I can do discovery or subpoena all of those conversations. Not that any of it matters, but good times. Do you feel slighted about the people who distance themselves from you? They feel awfully quiet, to be honest. No, it's just the white woman power. It is what it is. You blame them for not wanting to be associated with them? Yeah, I do. That's why I'm not going back. That's why after this case,
I'm surprised he hadn't brought up that Shiloh Hendricks or whatever that chick's name is who called a 5-year-old the N-word and talk about white woman power because now she's rich because she called a little black kid the N-word, which is wild. But I mean, it is what it is. You can't stop her from making money on GoFundMe to fight a legal case. She's gotten way more than she needs to fight that legal case. They're suing her, but, which I get the argument. The argument is freedom of speech. It's not against the law to use a racial slur. You have freedom of speech. But also, why am I stuck on this wall? But also, I mean, she did say something racist. So, it could technically be hate speech. I'm not sure if I don't think hate speech in and of itself is a crime, but it's used as evidence of a hate crime. Like, it's not in and of itself a crime. Because, again, it's not against the law to exercise your free speech, even if you're doing it in a racist way. Which is a common misconception. People think white people can't say the N-word and they can get in trouble for it. No, you can't get in any legal trouble for saying the N-word. Now, you can get banned from platforms and whatnot, but you can't get, into legal trouble because you said the N-word.
Done with. That's why I blocked them all. So we move on.
All right, and that is the end of the Destiny video. We now have entire document read to us and know what's going on. I don't know. I don't think this is as big a deal as I thought it was going to be. It sounds like Pxie's doing a lot to shoot herself in her foot. I don't know what kind of lawyer she's got, but he is contradicting himself a number of times in that document, and his actions are contradicting themselves too, because now you want it to be private, but before, Destiny is absolutely right. If you wanted it to be private, then you should have filed the motions privately. The fact that you filed this as a public motion, and now that it's public, you want it gone, does contradict your interest here. Aha, gotcha, bitch. Passed him at the last second. Booyah. Ah. Why is this the closest thing to Mario Kart of any game I played? It controls like Mario Kart. It's so fun to play with the boosting and everything. The boosting, the drifting, it's also similar to Mario Kart. The only thing that this mode needs, I swear to God, if Fortnite adds weapons to rocket racing, I don't know, maybe rockets, then you'll have an actual fucking competitor to Mario Kart. All you gotta do is make carts that are like convertible cars or something so we can see our characters in the cars and not just the cars. So you've already got a crossover with every fucking franchise on the planet. So you've already got a roster that would blow Mario Kart out of the water if you start making actual carts. Make a kart racing mode for rocket racing with actual carts to put all of these fucking characters we have in it. And that's it. You've already got a built-in competitor to Mario Kart right here. Look at this. I got Mr. Meeseeks here. I just picked random, land on Mr. Meeseeks, got Ninja Turtles. You've got all the most popular franchises on the planet in your game. Put them in go-karts and let them shoot each other. And just use the same controls from Rocket League, and you've got a competitor to Mario Kart. A free one that will blow it out of the water. They'd make so much money doing that. I don't know why they haven't done that yet. All right, but anyway, that's the Destiny stuff. Let me pull up Twitter here. I believe I had some tweets worth sharing. A little palate cleanser, a little something I got a little palate cleanser for us here. I've got a number of little things. One of which is, okay, this one was just funny. Doesn't have anything to do with anything. And then we'll get into the drama stuff. Which, first of all, Ozzy, are you still in the chat? Because have you seen this? I'll show this first. If you're still in the chat, Ozzy, check this shit out. you seen this yet, man? This is currently in the Minecraft preview build. People complained forever in Minecraft that there was no use for copper, myself included, that copper seemed like a useless ore. And here you have a copper chest and new uses for copper, including copper golems. And he's got a whole set of copper weapons down at the bottom bar, too. So check it out. The copper golems are sorting his inventory. I'm not sure how you tell him to do that, but this isn't a mod. This is just in the next Minecraft update. You can currently play in the preview build. I may download the preview build, just try it out. Just to fucking go mine it for copper and we'll try this shit out. But yes, they will sort your chest. Apparently you put a bunch of empty chests in front of the copper chest and they take the contents of the copper chest and start sorting it into the other chest. Not sure how it works. I may re-download the Minecraft preview build to try it out. Because I wanna see how that works. Alright, this one was fucking hilarious. Okay, I know we don't watch a lot of cop videos on here. You know. But this is another example of a cop chasing down a black man and giving him different treatment than he would a white man, okay? This shit needs to stop. These fucking pigs chasing down these black men. Just the way they treat them, it's bullshit. It's bullshit, chat. Look at this.
Shut up! All right. Your legs apart. All right. Turn around. Hey.
Yes! What the fuck?
I want to that guy.
I want to fuck that guy next. I fucking love Eric Andre. Oh, that was great. All right. So we got some drama stuff we can cover real quick for in the stream here. Oh, it's almost 4 a.m. It's 3:30, so we can cover a little bit more here. Which I got a long day tomorrow. I got work, and then I got my in-laws are coming because we don't have a car right now, so they're coming. So we can get some stuff done and maybe let us borrow their car, so they're going to stay here for a while. So I'll have a car until we can get another car. So I'll have in-laws here, which, you know, best behaviors territory. Anyway, so Asmongold thinks Hassan should be ashamed for letting his mods in his community run rampant. I want to see what he's referencing here. I think I've seen some stuff on Hassan's mod kind of going off today. So we'll see what this is.
So if Hassan is wondering why nobody wants to support him...
If you're protesting in LA today, please stop by the Kobe and GG mural and make sure it's still ruined.
...in his community, it's because your community is full of a bunch of weird fucking freaks. And I'm not talking like if this is a random person in Hassan's community, I wouldn't care about this. Who cares? That's not his fault. But when it's one of your moderators and this is a person that's representing your community and they're doing this, they're leading hate raids on other partnered streamers based off of a just completely, like, just totally baseless fucking lie, advocating for vandalism. This is pathetic. This is a joke, bro. Like, what the fuck is wrong with you? What is this? I don't know who this guy is, but I feel like
wait, what's that one say? Asmongold killed his mother by buying her cigarettes and surrounding her with filth. That's what he responded to this. Jesus.
The more that we find out, the worse it gets. The community has been a safe space echo chamber of a bunch of these psychotic retards.
True.
I know that. That's why I'm talking about it. That's explicitly the reason why I'm talking about it. My goal is to completely eradicate these parasites from the internet. And if nothing else, I want to completely change the narrative around whether these people are good actors or bad actors. These people are not good people. They're not on the right side of history. They're fucking bullies. They're fucking aggressive, abusive, vitriolic, mean bullies. And they lie about...
Cry bullies. They're cry bullies. But yeah, he's right.
...about people, and they tell bullshit about them, and they say whatever they need to say to make other people either stay silent or agree with them. And I think everybody should be against this, especially Hassan, because this is a person who's representing his community that's pushing this fucking bullshit. This is a joke. He should be ashamed of himself to have parasites like this. I can't even believe it. Like most people, yeah. Keep that in mind. And show the Mike from PA video from yesterday. It's crazy how polarized the internet is. Well, I don't know about polarized. I can't. Who can defend this? Who defends this? Do any of these people actually defend this behavior? There's no way they can. It's crazy. And so anyway, I think that these people need to. I think they need some repercussions. I think so.
I mean, like what, though? I mean, I don't know what you do about him other than ban him from that Discord, but like... and here we have Destiny reacting to Hassan going at Asmongold for aligning with him and Dan. Well, wait, did Asmongold align with him and Dan? 'Cause I don't think Asmongold... Is Asmongold... Who... No, it's Ethan. Ethan who's using redact.dev as a sponsor now. I don't think Asmongold is.
Yeah, that could be it. I think him playing Twitcher Terrorist was definitely a turning point for me. Especially because he was...
Is it not possible that anybody could just not like the fact that you openly support terrorism? Is that not a possibility that people just don't like you for that?
True.
Leaning heavily on aligning with Destiny and Dan Stalkman, Sex Pestiny and Dan Stalkman, when in fact he knew
Dan Stalkman? There's new nicknames for us every day. Okay.
how much they fucking stalk my ass.
How do we stalk you? What? You stream. What are you talking? What is stalking?
Yeah,
now stalking is when you respond to things that people say on stream?
Yes, they don't want people to
even
respond to
private
them.
Correspondence told me that he could not believe.
They say the same thing about Ethan and Asmongold. Oh, we're rent-free in their heads. They're responding to you. If you stop talking about them, same thing I said about Ethan, if you stop talking about them, they'll probably stop talking about you. Leave them alone. Just leave these people alone. But you guys can't stop throwing shots out there and then playing victim when they shoot back.
How much they fucking stalk my ass. But he still turned around and aligned with them because I guess he felt slighted, despite the fact that I was actually very charitable to him in that back and forth conversation that we had where he literally said Palestinians are an inferior culture that deserve genocide.
Wait, what?
He still turned around and slighted him in that back and forth conversation that we had where he literally said Palestinians are an inferior culture that deserve genocide.
Like, it's not even a fair summary of what Asmongold said. I'm not here to defend Asmongold. It's stupid, though, because it's not even... When you don't make the right criticisms, you don't even point out the correct flaw in the argument, right? We do actually have a very Western-brained approach to analyzing other cultures, such that if not the exact same as our culture, we tend to view all of them as being savage and barbaric and completely different.
I mean, I don't want to get into the politics part of it, but we've already proved that Hassan is pretty shit at debates. That's true, which is why he doesn't try to do them anymore unless he thinks he can win. And even when he debated like Willie Mack Show because he thought this is an idiot YouTuber, he doesn't know anything about politics. Willie Mack Show wasn't there to debate politics. He was just there to debate your video. So you still kind of lost to him. I mean, you did better against him than you do with other people, but yeah, you still kind of did bad. Like he's a bad debater. He just is.
Different. That's the issue with Asmongold's statement. But Asmongold didn't just say that Palestinians deserve genocide because they deserve genocide. He said that any ideology that demands for your extinction should also be extincted as well, which is a fair statement to make. He's just probably incorrect when it comes to analyzing the average ideology of all Palestinians. That was the error, but not that Hassan gives a fuck about accurately summarizing anybody's argument ever.
Palestinians are an inferior culture that deserve genocide.
Got your bingo cards out? He said genocide. We're probably going to get, let's see, we're probably going to get Zionist, Islamophobe. Yeah. Get your bingo cards out. It's a Hassan clip, guys.
He's he saying Asman said that or Ethan? I think he's saying Ethan said that. No, I think he's saying Asman said that. He's referring to the statement that Asman made that he got banned for a week for or whatever.
Also, yes, I'm not engaging in cultural relativism when I say that there's no such thing as like an inferior culture, because that is just a substitute for inferior people. Okay, no such thing as like an inferior in cultural.
Hold on.
Hasn't
Also,
he said
yes,
that before?
I'm not engaging in cultural relativism when I say that there's no such thing as like an inferior culture.
Hasn't he said that then?
Because that is just a substitute for inferior people. Okay, that's it. It's just a more polite, more polished way of saying you think some people are inferior.
Like that, the immediate ask should be, oh, okay, so the culture of Nazi Germany was not inferior to the culture of any other country? That's the immediate ask there. Oh, so all cultures are the same and equal? Like, what about the culture of 1950s America versus the culture of 2025 America? Was that the same?
True. Culture does mean different
The
than
culture
people.
is comprised of the people that uplift it. That's it. It's no different than saying, oh, I'm not saying black people are inferior. I'm saying black culture is inferior. That's it. There's good and bad to every culture.
Yeah, but culture, the argument against that is culture can change over time. Black person can't stop being black, but their culture can change. If they change their culture and your complaint is with their culture, then obviously you'd have no complaint with them. But if your complaint is that they're black, well, they can't stop being black. There is a difference between culture and race.
But ultimately, it all revolves around the material realities that people exist in.
What a retardedly stupid fucking state.
True. Was retarded and stupid. All right. That gets us caught up on the drama I cared about there. I don't care about the rest of this shit. What else did we have? We had, okay, yeah, that's all I had here. What about on YouTube? I think I had some other stuff planned, but I was going to do some Nintendo stuff, but that's like 30 minutes, and I only got 15 minutes before it's 4 a.m., and I do need to get some actual sleep, because I got to wake up a little earlier for work tomorrow to let the, say hey to the in-laws. I don't want to be rude. I don't want to I don't want to greet them as I'm going out the door, because they're going to be here crazy early in the morning. So, yeah, so that might be where we just stop tonight's stream, guys. Destiny being sassy, always. You know, he is a bitch. I mean, the guy does suck too, but he is kind of a pussy. He's kind of a sassy girl. But anyway. All right, that gets us caught up on everything. Tomorrow I'll probably do the Nintendo thing, and you know, if you guys got something you want me to go over, feel free to put up in the Discord, because I won't have much time to research it tomorrow, since I got in-laws here that are going to be keeping me busy. I'll try to post the VODs I got. I didn't get the one finished today, so I'll try to at least get that one done tomorrow. I don't know if I'll be able to get the second one done, because I forgot in-laws are coming tomorrow, so I don't know. We'll see how long they stay. I don't know if they're staying through the weekend or not, but I'm going to have a lot less time starting tomorrow, so I'm going to try to get as much done as I can before they get here, or before I have to, you know, get drug into family shit. For now, though, that's where we're going to stop tonight's stream. I'll try to post this VOD tomorrow. Like I said, if you guys got something new, you can put it up in the Discord, something you want me to go over. I'll do the Nintendo stuff tomorrow, and I got a few other things in the playlist I can fall back on I haven't covered yet, because we've been just stuck on this one drama forever. I think there's some new Pirate Software shit, too. Yeah, and you guys can check the comments, because Pirate Software's looks like Pirate Software stands are starting to find my videos, and the comments are coming out. I'll try to approve some of the crazier ones that YouTube's flagging, so you guys can see them. For now, though, I'm going to call it a night. So I want to thank all you wonderful witches for watching. If you're new to the stream, socials are above my head here. If you're a VOD watcher and you're new to the VODs, be sure to hit the subscribe button below. Help me reach 1,000 subscribers so I can actually get some ad money from YouTube. That would be great. That's the only metric I'm missing to be able to monetize my videos. I can monetize the live streams, and they happen every night at around 9 p.m. Pacific time. For now, though, that's going to do it for this video. I want to thank you guys for watching, and I will see all of you wonderful witches in the next one. Peace.